Good morning, everybody. Happy Wednesday. Welcome to the Courtroom Files Live. Reminder, Wednesdays are the new Fridays, so we treat this like a Friday and we have a great day. Let's start that great day with Judge McNally.
Concord versus Amanda Mount. Amanda Mount versus Concord, 2501975. Mr. Gallup.
Good morning, Your Honor. Creighton Gallup, P63002 on behalf of Concord Cooperative.
Ms. Mount?
Amanda Mount.
I'm at a loss as to what is going on here. I thought the case was settled, and I'm getting motion after motion after motion, and when people are done filing motions, they're filing more motions. I mean, everything from certifying a class to now motion for protective orders, sanctions for abuse of process. I mean, I don't know what to say anymore. Are you guys settling this or not settling this?
Your Honor, if I could interject here, we have mediated on at least 2 occasions with Judge Hessen, and I'd like to say on a personal note, I appreciate her efforts to try and get this thing resolved. I have submitted to Ms. Mount, this is on a second occasion, a revised agreement that I believe encapsulated the final terms that we had worked out with Judge Hessen after doing a walkthrough of her unit. First one, I was denied access, but Judge Hessen facilitated a second inspection. We went in there, and we believe we'd worked out a deal. I have provided that to Court Administrator Jen on Friday and a copy to Ms. Mount. I have not heard back from Ms. Mount as to whether those terms are acceptable or not. So the ball is in her court. The only motion that we have filed is after the 14th motion was filed by Ms. Mount last week. We just had to put an end to this. We just can't keep up with these motions. A lot of these are evidentiary in nature, and they're not relevant.
These kinds of things. You can raise this at the time of the hearing. Motion to strike police report and certain board member statements as inadmissible, misleading, and tainted by conflict of interest. Motion to preserve rights, objections, and defenses. I mean, I don't want to be rude. It seems like you're enjoying playing lawyer here, and that's okay. But at some point, I'd understood the case was settled. That's what I'd understood. Now I have seemingly I got stacks of stuff here. And I don't know what's happened. Can you just tell me what the basic tenet of the conditional dismissal terms were, Mr. Gallup?
If the court's comfortable with that, because I do know that she had filed a request for a waiver of the jury trial, and I don't want to cause any problems with you if you're going to be the jurist on this one, Your Honor. I can tell you it was a conditional dismissal in general that had arranged for some terms that she would be able to stay so long as the general rules had been followed. I don't want to get into all the specific details, but Judge Hessen worked very hard with both parties to get some middle ground here. I thought this was resolved. I've just not heard back from Ms. Mount from the proposal that was sent to her last week, which is the second draft, which incorporated newer terms for her protection after the inspection that we'd done with Judge Hessen.
Well, do I dare ask what the new terms were?
No, it specified certain items that we were going to repair in her unit that were basis of her counter complaint, things that she'd said that had been lingering that had gone unaddressed. It was all going to be taken care of here within the next 30 days.
I don't know what to say. I don't know what to say. I thought it was settled. Did they change something?
No, the habitability was settled, but not the misconduct.
Remind me, what specific misconduct?
Withholding my work order filing a police report when I wasn't even there.
So,
And it all started after I started enforcing my shareholder rights, for withholding a work order.
can you elaborate on that, Mr. Gallo?
Yeah, she keeps referencing these police reports that are not a part of the court record right now, and that's the basis of one of her motions. I really don't know how to respond to it. It's not a part of the court record yet. She's insistent on having a police report.
File police reports.
I had to do it. There was at least one or two police reports, one of which, when the police were contacted after there'd been a threat made about the site manager, she threatened that she was going to beat her up. And I believe there was at least one other police report sometime where she believes there's conflicting statements from maintenance guys that she wants to call as witnesses. I don't think there's any probative value here, that nothing's been submitted to the court as a part of this. And if this is something that would need to be excluded or included as a part of an exhibit at trial, there are limiting motions and processes that would be handled for something like that. It's very preliminary that she would raise this issue right now. I don't think it's relevant. Regarding the unit itself, she's made claims that her work repairs went unanswered. I think the court knows this. This has been part of the record. There were some delays due to COVID.
Yeah, you know, but that's not right either.
And that's why, and Your Honor, and we have worked diligently with the defendant, and we have worked with.
Do you have time limits in there and the conditional dismissal as to when all these repairs are going to take place?
Yeah, they were already supposed to have taken place last month, but she wouldn't let us into the unit. She changed that. Now it's scheduled, judges, but we'd rescheduled it pursuant to new agreement to the end of September, because it's going to require her and her family.
Slow down a little. I can't hear. I can't pick up two of you at the same time. You think I can hear you both and comprehend you both? Was a date set for them to come in?
Yes.
Did you let them in?
The first time, no,
Why?
because I would prefer an extra set of eyes, because,
Did you tell Judge Hessen you weren't going to let them in the first time without her being there?
no,
Why did you not let them in then?
Well, because there's bigger issues.
So they're seeking to have you removed. And it sounds to me like you're winning. That's what's befuddling. Hang on. It sounds to me like you're winning. If there's a conditional dismissal, Leonard, they have obligations, you have obligations, but as far as I can tell, you've won.
I understand that, Your Honor, but a conditional dismissal, I've done nothing to deserve a conditional dismissal. I did what I'm allowed to do.
Well, doesn't the conditional dismissal set forth that they're going to undertake all this work? And that there's to be no further violations by you, and as long as there aren't, that will be, the case will remain dismissed? Look, if you guys don't want to settle it, I have no issue with that.
Yeah.
All I know is I thought it was settled. And it seems like every single or every other third day it just seems like I get motion after motion. I come back from a conference, I got motions after motions here. And I'm thinking, what is going on? I thought we were waiting for a conditional dismissal. Did you graduate from college?
Almost.
Maybe you should go to college and go to law school.
Well,
If you,
it's not my intention. I have stage fright. Like, this is not what I want to do, but I do know my rights, and I know I didn't do anything wrong. And
all right. I understood it was settled. Is there anything else I can do to try to resolve this? You're right. If it's not a jury trial, I'm going to listen to the facts and I'm going to make a determination as to what the facts are and apply the law.
Your Honor, as far as I'm concerned, the ball is in her court. We provided a proposed agreement, a revised agreement. This is at least the second draft that we've given her last week, and I've not heard from her. So if she's telling the court and me today that she's not interested, we got to put this on the litigation track. I'd rather resolve it if we can. My clients come a very long way from where they were at, and it's just very frustrating that all this treasure's been spilt on this. These costs are getting assessed back against the members themselves. This is expensive stuff, so we just need a Fisher cut bait. I'd rather resolve it, but we have to go to trial. So be it.
Okay. I don't even know where to start.
Well, I can't hear very well, Your Honor. Did Ms. Mount, is she definitively saying she is rejecting what was provided to her last
The
week?
way it sounds to me.
Okay.
I can tell you're in the wrong court if you're talking about certifying this as a class action. Then I have other issues that I need to address, like well, how long are you going to be gone on vacation?
I'll be back the 17th, Judge. We do have a preliminary date for the motion that we'd filed, the motion for the protective order. The court had given us October 6th. I know the court doesn't want to put this out further than necessary. I've not received a response to her motion. We just filed it last week. So obviously she would have a little bit of time to respond.
We don't need to decide anymore. There's so many here.
You've only
I've got packet after packet after packet.
you've made decision on one general motion, which was her motion to transfer,
Right.
and we submitted an order.
Motion for reconsideration. I got emergency motion for protective order. I've got motion to preserve rights, objections, and defenses. Notice of waiver of jury demand. Police report is inadmissible upon hearsay. Motion to certify and transfer to circuit court. Motion for class certification. I think there's a couple more in here.
There were still 5 or 6 preceding from the first batch that she'd filed that the court has not had an opportunity to rule upon.
I know.
Yeah.
I don't even know. All right. Okay. Okay. Well, if you guys don't want to settle, you don't want to settle. I guess we'll just go forward. I will schedule Jennifer.
Yes, Judge.
A notice going out on all these motions. We're going to set them for October. Was it the 6th that we already set the one with Mr. Gallup?
We gave them the 6th as a tentative date, yes.
Okay. So if, okay, let me see here. All right. So I want you to set forth all motions that are going to be heard on that. I want it, I don't even know. So all motions, you're going to separately list each one.
And Judge, for quick reference, if you look at our motion for the protective order, I believe we listed them all for your convenience. I think we listed them. There's 1 through 14. That should help the court.
There's 14 of them?
I believe it was close to 14 that she filed. We've only filed 1 motion.
I thought there was more. I must be getting bad at counting. Motion for reconsideration will be the first one on the list. Set them all for October 16th. Any responses are due by
October 6th.
Register, if you would, by September the 29th. Can you do that, Mr. Gallup?
I believe we've responded to all of those, including the 2 recent ones she filed last week. I think
Match them all up and give them to me, Jennifer. If there's
Yep.
any other ones, you have to respond by September 29th. You
Well,
likewise have until September 29th, ma'am, to file any responses, okay?
The only other thing I'd ask the court, Your Honor, we've already relied on what we thought was an agreement to get these contractors out there. This is our duty anyway to make repairs. We're going to ask that the court order her to cooperate with any type of necessary inspections in the interim. There are a couple things that need to be done. One is the flooring. The second requires a contractor to come out there and displace them. We'd already made a hotel reservation to put them out. This could.
Tell
there's
us,
no reason to delay.
who out?
Because they're going to be renovating the bathroom upstairs. HUD requires them to relocate. We've already made arrangements when we're talking with Judge Hessen to get her and her family accommodations if they choose to use them, because they're going to have to rip out the bathtub and replace the flooring upstairs. These are the repairs that were scheduled for August that we rescheduled for at the end of September. If we reschedule it again, this may not happen until October, November, and that'll just
So
delay
wait a minute, when are you scheduled to do the work?
29th, September 29th.
Okay, and you paid for a room for Ms. Mount and her family?
They've already made one arrangement. They're making a second one. They're not out of money until she doesn't show up. We can still cancel. But my understanding is we're making another reservation for her for a period of a week. It's possibly a week it's going to take to do the upstairs.
What do you want me to order? Tell me what you want me to order.
That she will cooperate with the necessary repairs as proposed in the.
If you're going to complain about them not doing repairs, hang on.
Okay.
If you're going to complain about them not doing repairs, you need to let them in to do repairs,
I
right?
understand that, but my children's stuff has been stolen from the last time, so I appreciate it. If I could get them out of the house and do it without them worrying, because they're traumatized from the last time.
From what last
From
time?
our stuff being stolen from
When?
the contractors.
When?
When we were out last time in the hotel for 3 months.
Judge, I don't know what she's talking about. We have never had any reports.
What do you want to, I'm not following you. Do you want them in to do the repairs?
Yes, I did. I just, my kids.
Well, I understand, but do you want to take them to the hotel?
I mean, yeah, I don't have a problem. I just, everybody's showing up at the door. I would prefer just to keep them out of it as much as possible.
Well, tell
Because
them,
they're
wait a
afraid to
minute,
leave.
wait a minute, wait a minute. I'm trying to help you here. If you want the repairs done, they have to gain access to the property.
Yes.
So do we have a date for them to come in and effectuate the repairs? He says September 29th.
September 29th.
And she would leave on the night before, because we'll be there in the morning. We make the arrangements for the whole week for her to be staying at the hotel. We'd even change the location to make it more convenient and a newer.
Is that okay?
Yeah.
So you're agreeing to leave on the 28th of September and remain in a hotel until what, about the 5th of October?
Give or take, yes, Judge. That was their projection. And there's one additional.
Wait a minute, wait, slow down. I don't want to hear give or take. I'm not writing give or take in an order. Tell me how long it's going to take, and then she can agree to leave during those days, and you guys can have access to the property.
The contractor assured us it would be done by that Saturday, which was October 4th here. Let me look here.
So you're going to put them up in a hotel until the 5th?
Yes, absolutely. She will not be out 1 cent from that. We will make the arrangements for her. We're required by HUD to provide that to her.
Okay, so I want to make sure this is okay with you. September 28th, the night of you vacate,
Okay.
right?
Yeah.
You come back on the 5th.
Okay.
In what hotel? I want this all in an order.
It's in the proposed consent agreement. It is located off of North Line. It's the new Detroit Townhouses, I believe is the name of it. We've given her the information before. It was Judge Hessen's suggestion. It was a newer location.
Well,
Do you know where? Do you know where?
Well, there was like 2, and, last I knew, there was 2 different ones.
I just want to know, do you know which 2 they're talking about?
No, North Line, Detroit. I thought it was on Eureka.
It may be you're talking by 75. It's right there off 75. It's a new place. I believe it's a Marriott. Just it's on the south side of the road. We'll send her an email, Judge, Your Honor, and if we get done before, we'll be happy to let her
Can I
know.
put this in an order right now, and then I don't have to worry about this? This is so incredibly petty with so many things going on here. I want the hotel listed. I want the order saying she's going to leave the property to allow the plaintiff to effectuate repairs, which consist of A, B, C, D, E, and F, or whatever they are. And then that she's going to, the plaintiff is going to pay for and relocate her and her family to the hotel at the Marriott or whatever it is on whatever street in whatever city in whatever state.
We can do that. It's already in the order. All I gotta do is cut and paste, and I get it to you this
Pull
morning.
out your order. I have a feeling nothing's going to go right on this case. If Judge Hessen, if you guys were not allowed access to effectuate repairs, I mean, look, I'm not going to babysit here. I'm telling you right now, I am not about to babysit. That's ridiculous. She wants repairs. She won't let you in. You guys go in. Douse down being told people are stealing things. I'm telling you, I am not going to babysit. So put it right in your order. Pull out the conditional dismissal and tell me what we're adding in that order. And then I'm going to order it. And then there's not going to be any problems. And if somebody doesn't let somebody in or somebody doesn't show up with the contractor, there's going to be a serious penalty.
Yeah. So there are three portions of the repairs. The first one requires a contractor and her removal from the property or family. That's the one we're talking about starting September 29th. There's also a flooring issue in the kitchen where the tiles are starting to pop up. That is something that would be done internally. They do not have to be displaced for that. That can be done anytime from now until the 29th. All we would need is her cooperation. If we
all right, then you're going to put it in there. The flooring will be repaired on or before September 29th. Defendant / counter plaintiff shall provide contractors hired by plaintiff to gain access for the purpose of repairing the kitchen floor. What else?
The other will happen after, when they'll do painting and they'll do the what they call it, finishing work after the contractor.
When's that going to take place by?
That'll be right after the work that's done.
Let's say by November 1st,
Sure.
Plaintiff shall paint the residence wherever it is, whatever walls, whatever portion of whatever wall, maybe the 13 inches and 1 foot on the east wall, the north corner, but then don't paint anything else. You put this all specifically in an order, and I want it on here right now, please. I'm not going to go through this. This is nonsensical garbage as far as I'm concerned.
I agree.
I mean, you guys, I thought had an agreement, and I'm getting motion after motion, and I'm not gonna babysit. They don't pay me enough to babysit.
I agree.
So let's get the order. Let's put all the language in here, because I have a feeling when you submit the order, there's going to be an objection, and I'm going to have a hearing, and you're going to be in Italy, and then we're going to delay this, and I'm not delaying it. We're moving forth on this. So tell me. In fact, I want you to draft the proposed order now.
I'm working on it, Judge.
And I want it, Ms. Mount's not leaving until she looks at it and she approves it, and I'll sign it. You're going to send it to Jen. Jen, tell him where to send it.
Mr. Gallup, you can email me that at jen@33court.com.
Okay, Your Honor, I'll have it to you within the hour, probably within the next 20 minutes, actually.
Thank you very much. And then Ms. Mount, we're going to print out the copy of the order.
Okay.
I want to see it too, Jen. So when you give her a copy, I want to see a
Yes,
copy.
I'll print a couple copies and bring them down as soon as I get
Thank
it.
you very much. Thank you.
Judge, if I may, before though, they go, what time on the 6th for these motions? Do we want to do the afternoon or late morning?
What day of the week is that?
It's a Monday.
Well, I probably have sobriety for it, right? Don't I? Let me think. 25th, 8th, 22nd, the 6th is a Monday. Why don't you set them at 1:30 on Monday, the 6th?
Okay.
Okay?
Thank you.
Thanks.
Okay, Judge, let me get working on the order. Do you want me to pop back into the Zoom after we've sent it to you, Your Honor?
I do. I want you to send it to Jen, and then you can wait 10 or 15 minutes. She can look at it. I'll look at it. And if there's corrections to be made, we'll make them, okay?
It's only going to be about the repairs, and she's going to cover just the one portion, so we'll get it to you here. in
Just
20
be
minutes.
specific. I want to know where she's staying. Everything,
Understood.
okay?
Thank you. you.
Thank you.
See you.
Okay, everybody, good morning once again. Happy New Friday, because that's what a Wednesday is around here. Welcome again to the Courtroom Files Live. I will keep an eye on this and see when and if they pop back up. I'm going to go to Judge Mogan in just a second. She's about to do a sentencing for what I believe is a vehicular homicide. But before we do, some unfortunate news. This popped into my feed literally 20 minutes ago, and this is from KNSI Radio in Minneapolis. Where last night they had a shooting where there was one person left dead and 6 others injured. They have had a mass event now this morning. Police and emergency crews responding to reports of a shooting at Annunciation Church in Minneapolis. Authorities say they received a call about an armed man dressed in black with a rifle at the location. It's been declared a mass casualty event. Officials say approximately 20 victims so far, 4 listed in critical condition, 2 confirmed dead. They're also investigating reports of an explosive device placed inside the church. This literally just came 20 minutes ago, so I'm going to keep an eye on it. I don't have details beyond that, but yeah, I don't like this stuff, especially in churches. I mean, leave it alone. All right, let's go to Wisconsin, Judge Mogan, and see what goes on with the sentencing hearing, and I'll keep an eye on Judge McNally.
I'm positive.
Wait, how many are we expecting from Zoom? 2. I have Jessica, and who is the other one? Samantha. All right, thank you very much. Are in either of those going to be making a statement? Both of them are. All right, Samantha, I'm going to need you to unmute and just let me know that you can hear me and I can hear you. I'm hitting there we go.
Can you hear me?
I sure can, thank you. And Jessica, I'm going to ask you to do the same. Please unmute and let me know if you can hear me and I can hear you. Jessica, I've hit the button. Can you hit the button to unmute, please?
Okay.
Excellent. Thank you so much. We will get to both of you in a moment. Please mute yourselves when you are not speaking in the court, okay? Just so we don't have any unexpected disruptions. All right, just give me one other quick second. We will be good to go. We will go on the record in the matter 22 CF 184, State of Wisconsin versus Richard Thone. Appearances are we do have appearing in person the state through District Attorney Kevin Schmidt. We have Mr. Thone in person in custody with counsel Lance Nelson. We're set today in this matter for the sentencing portion of the case. Mr. Thone pled guilty to count 1, homicide by intoxicated use of a vehicle as a second and subsequent offense on May 19th, 2025. The court ordered a pre-sentence investigation report. I have reviewed that report and nothing stood out to the court with the facts known to the court as a material incorrect information or statement. We are in victims' rights compliance. We have victims in the courtroom. We have victims who are appearing by video who would be making a statement. Ms. Bauer, outside of the 2 by video who will be making a statement, are there any of the other 3 people here? I'm seeing 2 probably. Just one? All right, okay. So before we start with the statements, I'm going to ask Mr. Schmidt, have you received and reviewed the PSI report?
I have. I've reviewed it. I have no corrections.
All right. Mr. Nelson, have you received and reviewed that report?
I did receive and review it, Your Honor. I also went over that with Mr. Thone. I have no additional corrections or comments to be made at this time.
All right. And Mr. Thone, I'm just going to ask you to let me know if that's accurate. Did your attorney go over that document with you?
Yes, he did.
And did you notice any error or anything that would need to be corrected?
No.
Okay, thank you. All right, before we begin with the sentencing portion of this case, I am going to ask for the victims to make statements, please. I'm going to start with the individuals who are appearing by video, by Zoom. I will ask Samantha to provide her statement first. Samantha, you are not, you do not have your video working, just your audio, and that's A-okay with the court. But if you would like to have your video seen, please hit the video button and then you may start your statement. But first, either state your full name for the record or your initials, okay?
Okay. I am Samantha Kopinski Smith.
May you please spell Kopinski?
Yeah, absolutely. Kopinski.
Thank you. And is it hyphen Smith?
Yep.
All right. Thank you so much. You may continue.
Your Honor, my name is Samantha Kopinski Smith, and I am here because my mother, Jennifer Kopinski, was killed in this crash. My mom was one of the kindest, sweetest people I've ever known. About a year or so before her death, she surprised us all by moving back up to Wisconsin. She was so happy and optimistic when she came back, ready to reconnect with family and friends, start fresh, and be close with me and her grandchildren again. It felt like a new chapter for her, for all of us. She was just starting to really get close with her grandkids, to be a part of birthdays, holidays, and everyday lives. I was only beginning to see her really step into that role of grandma. She loved every second of it. We were finally getting to enjoy life with her again, and then I woke up one morning and she was just gone. The shock of losing her so suddenly and in the manner that it happened has left a hole in my heart that will never heal. She must have been so afraid, probably thinking of me and my boys. I know I would be thinking of my children. It is hard for me to understand how someone can be so careless with something they claim to love so much. Her death was completely preventable. There is no reason that she shouldn't be here right now. And the choices that have caused it have left a lasting impact that no sentence can erase. We feel this loss every single day, and our family will never be the same. I am asking the court to hold Mr. Thone fully accountable. I support the PSI recommendation of 16 to 18 years, and I believe a strong sentence is necessary to reflect the seriousness of taking a life. Nothing will bring her back, but I hope this sentence sends the message that reckless decisions have devastating consequences and that justice must be served. Thank you for your time, Your Honor.
Thank you, Ms. Kopinski Smith. I am now going to ask Jessica Glosky, and it's spelled Glosky. Is that correct, Ms. Glosky?
Yes.
I am now going to ask you to present your statement to the court.
First off, to Rick, your careless actions, the drinking, the reckless behavior has resulted in a major loss for our family. You have taken Jennifer away from us in a horrible, unspeakable way. I wish she would have left when she had the chance. 2 little boys are now without their grandma, and to have told them that she's never coming back was the most heartbreaking. One would think after a very similar UTV accident 4 months earlier, you would have had a wake-up call to stop drinking. You almost killed her then. When you love and care for someone, you do all you can to protect them. With your actions in just a couple years, you have proven you never really cared. I believe you should be held accountable for your actions to the fullest. You need to take responsibility for what you have done. Judge, I ask you to please give the maximum sentence. I do not feel Rick should get out with his impulsive behavior. He'll just continue his recklessness. Please do not let him risk someone else's life. He has proven that he cannot be trusted to repeat again. Thank you.
Ms. Glosky, what is your relationship with the victim?
Her niece.
All right. Okay. Thank you so much. All right, Ms. Bauer, may we have the other individual, please? And they can come and have a seat over there at the black desk. And please either state your name for the record, or you can state your initials. And I didn't want to interrupt Samantha or Jessica during their statements, but if you're going to read something, please read it slowly, so that not only can we all understand it, but so the reporter can take it down.
Okay. Okay, my name is Janet Klopinski. I am Jennifer's sister. It's gonna be hard.
And I understand that this is very emotional. So please, if you need to stop and take a breath and to calm yourself, you may do so. We are not in any rush here today. This is our main focus. And there are Kleenexes right there. But again, take your time.
I don't know if I can do it.
Ms. Bauer can read it for you if you would like her to do that.
I have to. I can't. I mean, it's pretty similar, but I'm sorry, I just can't.
There's no apology necessary. This is very emotional.
You have to do the phone and I'll just read what's on the phone. Rick, because of your reckless behavior in August 2024, you took my sister Jennifer from us. You took Samantha's mother, Max, and Alistair's grandmother. You took an aunt, a cousin, and a special friend. To so many. It wasn't the first time you caused harm to Jennifer. The accident in May left Jennifer with serious injuries. You would have thought you would have had straightened up and stopped your recklessness behavior, but you didn't. Because of this, you should spend the rest of the days locked up to think about what you have done to Jennifer and her family. I miss Jennifer every day. Because of you, I will never see her again. Judge, please sentence Rick to the maximum sentence. He has been reckless with his life. He shouldn't have the ability to destroy another family. Sincerely, Janet.
Thank you so much. All right, you may go return to the gallery. Mr. Schmidt, I'm now going to turn to you for the state's argument and recommendation.
Thank you. My recommendation is going to be a 17.5-year recommendation broken up into 7.5 years initial confinement, 10 years extended supervision. So that's a little bit lower than the PSI in the initial confinement, a little bit longer on the extended supervision. The general purposes I think the court should weigh heavily on this one would be incapacitation and protection of the public, as well as general deterrence and punishment. I'm going to talk a bit about specific deterrence and rehabilitation on this because there's things to be said about it, but I think they take a backseat on this one due to certain content in the PSI. I think that my recommendation is necessary to not depreciate the gravity of the offense or the loss suffered by the community and the family of the victim. There's really only one place I can possibly start in this argument, and it's with this. Richard Thone killed Jennifer Kopinski. She was his fiancée. They had been together for a substantial period of time. From review of this case, as well as my review of other cases, including Barron and Douglas, they obviously loved each other deeply. His remorse at what he's done is genuine to his benefit. He has obviously both inflicted and suffered a great loss because of his actions. I don't think anyone could legitimately disagree with that. I state those things to make the general point, not just with Mr. Thone, not just with the family, that in this case, a great loss has occurred. And as a result, this is a high severity offense. This is a high gravity offense and prison is necessary. That's why the legislature made this offense have a statutory minimum of 5 years initial confinement, which to compare, 5 years is higher than the statutory minimum of OWI 10 or 20 or 50. Legislature thinks when someone dies as a result of an OWI, it is more serious than the most serious OWI offense. So this is a prison case. Mr. Thone could be sentenced to up to 25 years initial confinement, up to 15 years extended supervision. DOC recommends 9 to 10 in, 7 to 8 out. Mine's a bit different. So I'm going to describe what I think are the aggravating and the mitigating factors. The loss to Mr. Thone is the main mitigating factor. There's another one I'll allude to in a bit. This is an offense that involves alcohol, driving, and harm done to Jennifer Kopinski. And what's disturbing about that is when you look at Mr. Thone's history, you see a pattern of those three things, not just in terms of physical injury, but other impact as well, other negative influence. So I'm going to touch on something that I think one of the victims mentioned because I think it's an important theme of this case. One, that this death was both imminently predictable and imminently preventable by Mr. Thone. Second thing I want to point out is that the history demonstrates this and demonstrates Mr. Thone's lack of ability to change his behavior to prevent this predictable death, despite his professed love for the victim and his professed remorse for her death. He seemed to drag her down with him in his own apparent despair about his own health conditions. Part of that is obvious from the PSI. The agent hit on it, and I've talked about it at past hearings in this case. 4 months before this event happened, a similar event happened in Barron County. Richard Thone rolled a black Yamaha UTV or ATV in Barron County and BT'd there above 0.08. Both he and Jennifer were injured. That is, she was with him at that one as well. What we didn't know prior to the PSI is that when Mr. Thone was interviewed by DOC, because he was still on probation at the time that happened in Barron, he himself had recognized that they were lucky to be alive, and he claimed he would never drink again. He claimed that he had been impacted by that case and the potential threat to their lives by the danger of this ATV rollover while he had been consuming alcohol, and he wouldn't drink again. 4 months later, he did drink again, he did drive again. Ms. Kopinski is with him again and driving really the same type of vehicle, a new black Yamaha ATV. He bought a similar one to the one he had rolled previously. And it crashed, and Ms. Kopinski was not lucky this time, like she was the first time. Mr. Thone agrees in the PSI that he was intoxicated, but he also seems to complain that there was also something wrong with the trail in some manner. So he is accepting responsibility, which is a positive. It is disheartening that Mr. Thone would do the exact same thing 4 months later. That nearly dying and nearly killing Ms. Kopinski 4 months earlier did not actually change his behavior. That alone did not have a specific deterrent effect on Mr. Thone. The consequences to himself, injuring himself, to injuring her, to nearly killing both of them, to DOC's actions in response, that was not sufficient for him to specifically deter his behavior for even 4 months. That is not the only injury that Ms. Kopinski has been exposed to by Mr. Thone. To elaborate a bit more on that, I think it would be helpful for the court to have some more information about that DC obstruction that occurred in Douglas County that's mentioned in the past history in the PSI. According to the police reports in that past Douglas case, a Douglas County deputy had a call that people were alleging that Mr. Thone and Ms. Kopinski were being disorderly at a tavern. On the way there, he happened to see their vehicle passing. He shined a spotlight on the driver's side and affirmatively saw a male driver and an unknown passenger. So he hung a U-turn, pulled the vehicle over. He could visually see as he was approaching, he could see the driver moving into the back seat and the passenger moving into the driver's seat. When he approached the vehicle, it was Ms. Kopinski who was sitting in the driver's seat and Mr. Thone sitting in the back. They claimed that she was driving the whole time and that Mr. Thone hadn't drank at all, another thing that was proven false later with subsequent tests. As a result, Mr. Thone was convicted of that obstruction for lying about that. And in fact, Ms. Kopinski was also convicted of obstruction in Douglas 22 FO951. Under Mr. Thone's presence and influence, I can't say direction because I don't know that. Under his influence, she was willing to lie to shield him from drinking and driving where she was the passenger in the vehicle. I think that's a necessary component of looking at this pattern, because this isn't just look back 4 months at what happened in Barron County. I think the court should look back further to that Douglas County 2022 case to see there's been further signs of this kind of influence, this negative impact on her life. That under his influence and in his presence, she would be willing to lie to protect his continued behaviors of drinking and driving. I think I want to demonstrate that to the court because it shows there isn't just the single aggravation of what happened in Barron County. There's aggravations, plural, with this longer term, this longer pattern of undesirable behavior is the language we use in sentencing language. This longer pattern of detrimental effect on the victim, in this case, Jennifer Kopinski, not just the physical injury in Barron, but the negative influence we saw in the Douglas case. It contrasts very starkly with the account we get from the victim impact statements, both orally in court today and the ones filed with the court. There is something Mr. Thone mentions in the PSI as though it's a mitigating factor, and I suspect the defense is going to argue it as one too. That is the fact that Mr. Thone has a disease called Huntington's disease. Huntington's disease is a horrific genetic disorder. It causes profoundly negative, degenerative, impactful symptoms that only worsen and worsen until the person dies. It's really terrible. I feel truly sorry for anyone who has it, including Mr. Thone. But in this case, I have to talk about it because it's a double-edged sword. What I mean by that is, right off the bat, with the severity of symptoms Mr. Thone describes in the PSI, there's a real question of why is he driving at all? Not in terms of, is he legally allowed to, what could you do? I mean, the question of what should you do? The way he describes how it impacts him in all the myriad ways, the way that it's mentioned that the doctors have questioned it in the past, it certainly doesn't seem safe for Mr. Thone to be driving at all if his condition is as he describes it, and yet he continues to do it. I think that's further exacerbated and becomes an aggravating factor when we consider the fact that the PSI clearly contemplates it's not good to be consuming alcohol if you have Huntington's and you're taking the appropriate medications for Huntington's. That's also a bad idea. It worsens, and that way it's aggravating. The fact that he still does it should be concerning. In the PSI, it seems Mr. Thone is remarkably capable of speaking about the effect of his Huntington's, the symptoms of the Huntington's. He's a very good historian of that. Yet he doesn't seem capable of modifying his life, his behavior, his actions in light of what he clearly knows about the symptoms and the impact of Huntington's on him. His sister's theory, according to the PSI, seemed to be that she believed that he's come to some sort of place in life where, rather than this being this drinking and driving behavior, this repetitive behavior that started late in Mr. Thone's life, rather than being a result of a cognitive problem from Huntington's, that it's more of a, pardon my language, like a what the hell attitude, where I have this horrible disease, it's going to get worse, I'm going to die, who cares? Why not? Why live for tomorrow? Why not live for today? You only live once kind of attitude. Furthermore, when you see the chief complaints that Mr. Thone talks about in the PSI about his Huntington's, he spends a lot of time talking about memory deficits and ability to remember things, about basically anything. He shows real struggle to do any of that in the pre-sentence investigation report. The way he describes in particular the memory effect of his Huntington's in the PSI leads to the obvious conclusion that it seems unlikely that he would be a person who'd be a candidate for believing he will be specifically deterred by impacts of his own conduct, or that rehabilitation will be easy or fast or successful at all. He will have difficulty learning because of these memory deficits he describes that he claims are from the disease. If rehabilitation is unlikely, if it's going to take a much longer period of time with Mr. Thone because of the Huntington's, because of these memory deficits he has, if we can't rely on the idea that, hey, you know, my fiance got an obstruction charge and my fiance nearly died in a rollover in Barron. My fiance actually died in another rollover in Burnett. We can't believe that that is going to have a specific deterrent effect on its own. That's when we have to talk about a longer period of incarceration, a longer term of treatment and confined setting, a longer term of practicing sobriety in a controlled setting rather than in the community. It already failed in Burnett County previously because, again, he was on supervision. I'm sorry, Barron County previously because he was on supervision. The end result of what all I've said is I think there's a great deal of information in the PSI to lead one to the conclusion that Mr. Thone is at a minimum resistant to change. For years, he has been with this woman he's claimed he deeply loves, and he's dragged her down. There's no doubt about it. He's put her in danger. He's brought her into his spiral about his condition with Huntington's. He co-opted her into lying for him in Douglas County. He then, in his own words, got lucky when she didn't die when he rolled an ATV in Barron after drinking. 4 months later, he buys the same model of ATV and rolls it again in Burnett County, and he kills her. It was predictable. It was preventable. In fact, Richard Thone, in fact, did predict it. I think you have to characterize his statements to DOC, mention the PSI about the Barron rollover, about we're lucky to be alive. He did predict it. He did predict that if he did the same behavior in the future, she could die. They might not get lucky. He predicted it and he didn't prevent it. I think Mr. Thone, ultimately, when you look at the history of undesirable behavior among these three cases, you have to conclude that he's a somewhat selfish person with a horrific disease that caused him to abandon really hope for the future, thought for the future, and the people in his life that he loves that might live beyond him in it because of his own thoughts about his Huntington's. And that's terrifying because what reason do we have to believe this won't happen in the future? One of the victim impact statements cautioned the court, we don't want this to happen to another family in the future. This is a situation where he harmed someone close to him, but it could have easily just been another ATV on the road or crossing a highway, a motor vehicle. Because of that, the community has to be protected. The next Jennifer Kopinski has to be protected. Richard Thone has shown nothing to cause anyone of rational thought to believe that he will stop. 7.5 years initial confinement is necessary to incapacitate him, to protect the community, to generally deter people like Mr. Thone, and to have higher odds of specifically deterring him and rehabilitating him in a controlled setting. The 10 years extended supervision will likely be enough to make sure DOC can watch him carefully, possibly with his diagnosis the rest of his life. It is now more predictable than ever that Mr. Thone could pose a serious risk in the community. He is telling you himself in the PSI that his disease makes it unlikely that he is going to remember details that would normally have a specific deterrent effect on a person. He's demonstrated a consistent pattern of undesirable behavior that has not been shaken by terrible consequences to him, to people close to him, even prior to this incident. This sentence is how you prevent it. 5 years, the statutory minimum, would be too little for a case like this where there are aggravating factors. The pattern of undesirable behavior, the influence on the victim, leading to her death, especially when it's repeating that previous dangerous behavior so close in time, only 4 months. We're now at the point where the court, rather than Mr. Thone, is best postured and positioned to prevent what is predictable in the future. I appreciate that Mr. Thone has a terrible disease and he's of older age and his criminal history is not exactly lengthy. Those are factors that are often used in COMPASS and other risk assessment tools to predict recidivism. But I think that when you look at all the history began later in life with the late life Huntington's exacerbation, it tells a different story, a more nuanced one than that simple statistical fact that older people commit less crimes, people with less convictions commit less crimes. I appreciate he's had somewhat of a consequence already with obviously the person he loved died and died at his hands. That's why I'm not arguing the max in this case. The max could be much, much more, but I cannot countenance arguing the minimum either with the aggravating factors described. Thank you.
All right, thank you, Mr. Schmidt. Argument, Mr. Nelson.
Thank you, Your Honor. I want to address a couple of things that the state had mentioned, specifically with respect to the Douglas County offense from 2022. I actually represented Mr. Thone on that matter, and so I can maybe shed a little bit of light into what was going on there. He was initially charged with an OWI in that case. That was later dismissed due to evidentiary concerns. I don't think it had to do so much with whether the state was going to believe or a jury would have believed Ms. Kopinski was the driver. I don't think that was the issue. The issue that actually came up in that case was with the arresting officer, that sheriff's deputy. I think there had been some misconduct that had been occurring with that particular deputy, and that deputy no longer works for Douglas County anymore. So he had been dismissed, and that was a major. I wish I could take credit for excellent lawyering in that case and getting the case dismissed, but that's not really what happened, Judge. So there were issues there with the credibility of that officer and the ability to call that officer as a witness. And that's what resulted in that. So, as a result, I mean, Mr. Thone certainly claimed innocence in that case, and Ms. Kopinski backed him up in that regard. And there's some other issues there too that Mr. Thone was upset about that transpired in that case. I really can't say for sure what happened. I mean, I don't know. Nobody knows. So it was never proven one way or the other. But that's what happened in that offense. I think it was mentioned in the PSI. There was an official diagnosis of Huntington's with Mr. Thone in 2020. And then there was a genetic confirmation of that in 2021. But there's also mention in the PSI that I don't know if it was friends or family or what, but that they had noticed what they regarded as symptoms probably for a couple of years before that. So I think realistically, if we're looking at a time frame for Mr. Thone's Huntington's issues, we're probably talking about an onset of around 2018. Looking at his prior history, Your Honor, there was a 2016 first offense OWI. Unfortunately in Wisconsin, it's not uncommon to have a first offense OWI. But if we're talking about really repeated instances like Mr. Schmidt was referencing, realistically, if you look at the timetable, the timeline of those, it really began around 2018 and proceeded kind of pretty consistently from that time on. I'm not an expert in Huntington's disease, but I think it is a little unusual for a person, Mr. Thone at this point is 56 years old, to have gone, 45 years plus of life without seeming to have a problem with alcohol, without seeming to have a problem with driving or any of these issues, any of these recklessness types of issues. And then right around the time that this Huntington's disease emerges, he starts to have this very impulsive type of behavior. And it just suggests to me, and again, like I said, I'm not an expert in Huntington's, but the timeline just suggests to me that there's something that's affecting him cognitively, his impulsive behavior, this reckless behavior. And, part of that too is denial. And just an inability necessarily to recognize, to have the insight to recognize how something may be affecting you. Mr. Schmidt mentioned the rollover in Barron County. Well, that for anybody, any normal person, I think that's certainly an indication that hey, you just dodged a bullet. I mean, that should have been a shot across the bow, so to speak. And Mr. Thone seemed to acknowledge that he was lucky to have made it through that without anybody receiving any significant injuries. But he still sort of wrote it off as well. It was the trail conditions and those kinds of things. And I just think that's an indication of denial. And so, those are things that unfortunately, I think clearly contributed to the current situation that we find ourselves in and the unfortunate loss of Ms. Kopinski's life. But I don't think that he has any basis to deny his problems at this point. And he certainly hasn't shown that in about 9 months or a year that I've been on the case talking to him about it. Your Honor, this is a difficult case to have. It's always difficult whenever there's a case that involves a loss of life. This is a situation where I wasn't, best friends with Jennifer Kopinski or anything. I don't want to make it seem like that, but I certainly did. There was never a situation, Your Honor, where I dealt with Mr. Thone and didn't deal with Ms. Kopinski. They were together constantly, and Ms. Kopinski in many ways was Mr. Thone's biggest defender. And there are many times that Mr. Thone would talk to me about his case or something that was going on, and had a hard time communicating. And Ms. Kopinski would jump in, and she would be the one that stuck up for him and advocated for him. I think that he relied on her a lot. And I don't think that there's kind of been a suggestion that, Mr. Thone doesn't care about what's happened or that his feelings for her were not genuine or something. And to me, that's crazy. That's a crazy assertion. I don't think there's any basis to conclude that. I think that they were two peas in a pod. When I had heard about this case and the fact that she had lost her life, it was very sad to hear that. I liked Ms. Kopinski. She was a nice lady. And it's very heartbreaking to hear that this had happened. And for what it's worth, Mr. Thone has never indicated anything other than that he is absolutely devastated by what he's done. And, a case like this, the National Highway Traffic Safety Administration used to have these ads on television. I mean, the court might have seen these, but they're like a PSA ad, and it's to try and convince people not to drink and drive. And to sum up the substance of the ad, it's a person leaving a bar and they're going to get into a car and drive. And the suggestion is that they've been drinking, and then sort of behind the bushes, the state trooper peeks his head out, and it's like, you think that you're going to get away with drinking and driving, but we're out there and we're going to catch you. And I know that they probably spent a lot of money on those ads, and they had probably smart people that were working to make those messages. But I always thought that those were really dumb ads, frankly, and I thought that they really were a missed opportunity. Because I never thought that the reason that you don't drink and drive is because you might get caught. I never thought that that was the real reason. That makes it into almost like a game, you know? It's like, if I make it home, do I get extra points if it was a longer drive or something like this? It's sort of a stupid way to think about this. The real reason that you don't drink and drive is this case. This is the real reason you don't drink and drive, because Mr. Thone, who doesn't remember anything, he was also injured in this accident, and I think was found more or less comatose or moderately unresponsive when the EMS workers came to the scene, but had received a good knock in the head. But at any rate, Mr. Thone more or less came to or woke up in the hospital and had to be told that all of this happened, and has had to process that now he's responsible for this. And this is something that he wakes up every day and has to think about the loss of Ms. Kopinski and his relationship with her and how he misses her, and the companionship that she provided for him and their connection to one another. I don't think that Mr. Thone had many family ties. It seemed like he was kind of estranged from his family. I know they talked to his sister, who kind of seemed to indicate she didn't have much to do with him. Sounded like he didn't have a whole lot to do with his son, who lives in Washington, D.C. They might have been somewhat estranged. Maybe they were starting to make inroads there, but didn't have a lot of connections to them. I think Mr. Thone really relied on Jennifer Kopinski. I think they were kind of each other's world to a certain degree. This was the only person that he had in his world that prevented him from being completely alone. And her loss has been absolutely devastating to him, and it's affected him in a profound way. Everybody feels the same way about this case, including Mr. Thone. He's completely disgusted, upset, sad, despondent, angry at himself. I have yet to have a meeting over the course of representing him on this matter where he has not sobbed at some point during the discussion, the conference. He's been emotional consistently with respect to this, and this has been something that's greatly affected him. In terms of him taking ownership or accountability for this, Mr. Schmidt and I had certainly talked about the particular offense that Mr. Thone was pleading to. As Mr. Schmidt indicates, this is a prison case. I think statutorily it's a prison case. I don't think the court has any leeway there. I don't think the court can suspend a sentence. I think the offense itself mandates a bifurcated sentence. He's got to have a bifurcated sentence. So this was discussed. This was absolutely discussed. And furthermore, it's not really a hard mandatory 5-year minimum. There's grounds there for the court could dip below that, but realistically speaking, it's a 5-year minimum for all intents and purposes. And Mr. Thone accepted that. So by virtue of his plea. So I don't think that Mr. Thone is trying to avoid accountability here. I don't think there's any reason to suggest or to imply that his grief or his feelings of accountability for this are not legitimate. I think clearly it's the case, Your Honor, that Mr. Thone has been affected by this greatly, and will continue to be affected by this for the rest of his days. I don't think he'll ever forgive himself, Judge. In looking at this, Your Honor, I've represented people for about 20 years now, and it's been a couple of thousand cases that I've had over those years. And when thinking about sentencing, just philosophically about sentencing, I think one of the interests that you kind of have is you want the feeling that in some way that you've reached the defendant a little bit. I've heard a statistic a long time ago. I think it's probably accurate that if you took away the offender's that have committed 3 or more offenses, you would reduce the overall crime rate by something like 80%. So in other words, 4/5 of the crime is committed by people that are multiple offenders. And you've got a tiny nucleus of people that are really causing most of the criminality that exists in the country. And there's a lot of interest in trying to find ways to stop that recidivism and to make some kind of cognitive change with those people. And some of it is the idea of deterrence with lengthier prison sentences, that maybe this would be a deterrent that would help people to modify their behavior to not be not commit offenses in the future. And that's a legitimate philosophical motive for looking at a lengthier sentence for someone. As I indicated, Your Honor, I think that this is something that has been a complete shock to Mr. Thone. I used the word denial before. I think that he was in denial. I think that he's beyond that now. I think that he's left that behind. I think he's had to, the circumstances. He talks a lot about Jennifer. When I talk to him, he talks about missing her. He talks about thinking about her, dreaming about her, speaking to her in his dreams, those kinds of things. This has been something that has been weighing on him greatly during the entire case. And I don't think he needs to be reached any longer. I think, it is a prison case. There's a loss of life here, unforgivable loss of life. I want to echo Mr. Schmidt. Mr. Thone's issues with Huntington's disease, he's on medication. He should never be drinking again. He should not have been drinking. And nor should he be driving, I don't think. I think there's enough, what I've read about Huntington's disease, there's enough there about how it affects your motor skills and things. I don't think there's any way that he should have a license. And he shouldn't be operating. He never should have been. He probably should have been, he should have hung those things up maybe in 2022, so that was, I think that's clear at this point. And I doubt that he's ever going to be able to drive again. He may get his hands on liquor at some point. I hope not. But he certainly has said, I'll never drink again. I know he's been doing AA in the jail. There's not a whole lot of programming there. He's not eligible. We talked about, Your Honor, he's not eligible for ERP due to the 940 nature of these offenses. He couldn't earn early release, but I think that he would probably benefit. It would probably be important for him during his period of incarceration that he would make use of the substance abuse program regardless. So I would certainly ask that the court would deem him eligible at least to attend those sessions, even if it doesn't result in a modification of his sentence at all. I think that would be quite important for him to do. So, I think a 5 years is the minimum or thereabouts. I think that that's a sufficient amount of time, does not diminish the seriousness of the offense. And I think a further sentence, a longer sentence, you start thinking 6, 7, 8, 9 years. I think the concern that I have, Your Honor, relates to the progression of his Huntington's disease. I think since 2022, when I met him, or 2023, when I met him, I think he's probably a little bit worse, Your Honor, over that time. I think the last year obviously has been pretty stressful. Obviously, so I think that has not been helpful to him. I did look up some stuff about Huntington's disease from the Cleveland Clinic website. which I would read for the court. I think it's important for the court to consider this. This is from the Cleveland Clinic, which I guess is a research hospital. This is from their website. How does Huntington's disease progress? Huntington's disease is a progressive condition. This means it slowly gets worse over time. The way the condition progresses varies for each person, but may include, at the early stage, symptoms are mild. You might feel moody or clumsy and struggle with complex thinking. You may also have small, uncontrollable movements, but typically you can continue your everyday activities. I think that this probably describes Mr. Thone's Huntington's disease, at least up to the recent period. However, in the middle stages, according to Cleveland Clinic, physical and mental changes make working, driving, and household chores very difficult. You may have trouble swallowing, which can make speaking and eating meals challenging, but not impossible. Your balance may be off, increasing your risk of falling. You can still manage your personal care like bathing and getting dressed. And I wonder if he hasn't slipped into that middle stage at this point. I think just some additional difficulties, Your Honor, in understanding Mr. Thone. His gait is not exactly the same as it used to be. And I think he may be entering into that middle stage. And then at the end stage, according to Cleveland Clinic, completing daily tasks is hard to do on your own. Most people aren't able to get out of bed without help. You'll need around-the-clock care during this stage, especially to eat, bathe, and monitor your health and well-being. So, I'm a little concerned if you're talking about a lengthy prison sentence, that he's probably beginning to slip into the middle stage, and how much longer would it be until he's in that end stage situation where he's needing help even to get out of bed. Also from the Cleveland Clinic, what is the life expectancy for Huntington's disease? The average lifespan after Huntington's disease diagnosis is 10 to 30 years. So there's a bit of a range there, Your Honor. Obviously, there's a big difference between 10 years and 30 years. But if we're thinking that symptoms probably cropped up around 2018, 10 years is 2028. And so that's he's in that range where could reasonably be expected to have potentially life-threatening or high impact on his quality of life progression of the illness. So I think the court obviously should do what it feels is necessary and appropriate in this case, given the statutory factors. I think that it probably is not in the court's in the interest of the system that Mr. Thone be at Stanley or wherever he ends up needing round-the-clock care. I don't think that that's appropriate. So I think that mitigates towards a sentence closer to 5 years than closer to either the 7.5 or the 9 or 10 that's recommended. So our recommendation, Your Honor, we don't duck the idea that this is a prison case. It's obviously a prison case. We would suggest a period of initial confinement of 3 to 5 years range, somewhere in there, with extended supervision of 5 years. And again, as I said, I think he could make use of that substance abuse program while he's in custody. So I think that would help him.
Thank you, Mr. Nelson. Mr. Thone, I'm now going to turn to you to see if you wish to make a statement in court here today. It can be about anything involving the case, the situation. You don't have to make any statement. It's just your opportunity if you wish to do so.
I'm sorry for everything that's happened, and I'm ready to do the punishment that I'm going to get for it. That's it.
Thank you, Mr. Thone. Mr. Thone, you have been in court before and you've had a couple convictions that are on your record, but you don't have a very extensive criminal history. You have the disorderly conduct and the resisting or obstructing an officer, that Douglas County case. You have an OWI second from Eau Claire County in 18 CT 94. You have Trumpereau County with your OWI first. You have that Barron County matter that was extremely similar to this case, except for the fact that you both were only injured and no one died. So you don't have a very extensive criminal history or knowledge of what occurs in a sentencing. So I will go over them with you so you can understand. If I'm going too fast, please let your attorney know so I can slow down, so that I know that you understand everything, okay?
I didn't understand what you said at the beginning of all that.
Okay, thank you. So when a court sentences an individual, I must first look at the nature and the gravity of the offense. How serious is this matter? Then I have to look at your character, your past criminal record, needs for rehabilitation, those types of things, take into account your Huntington's disease, as well as your education, all factors related to you. The third thing that a court must look at is needing to protect the public. And that means protecting the victim and the victim's family, as well as protecting the community as a whole. And when the court looks at protecting the community, there are other factors that come into play. The court has to look at, again, do you have rehabilitative needs? Are there needs that you have that services can be provided, such as treatment, those types of things, and we can see you rehabilitate. We can see you change your life, change your conduct. The court has to look at undesirable behavior patterns. Has this happened before? Do you have a history of doing things similar? The court looks at your culpability. How much of this is your fault? I have to look at, again, deterrence, as Mr. Schmidt pointed out in his argument, deterrence, specific deterrence, some type of punishment and sentence that would deter you from continuing in this type of behavior and actions, and otherwise general deterrence, a sentence that would deter others from engaging in this type of conduct, or for taking a second or third thought, do I want to do this? What could the ramifications be? What could the outcome be? Because as Mr. Nelson stated in his argument, this is very serious. This is an OWI offense that resulted in a death. And so it's very serious. And OWIs are not a game. It's not how can I get home? Can I get home the quickest? Do I get more points if it's a longer drive and I make it home safe, even though I know I'm intoxicated? It's not a game. It's life and death. And here we had a death. So again, it's very serious. I've heard the arguments of both of the attorneys. I've heard your statement. I've heard 3 victim impacts statements and how this loss has completely traumatized this family. And I don't necessarily want to say destroyed the family. Hopefully it has been something to bring the family closer together, but it is a loss that is immeasurable. They will never get to see Jennifer again. The grandkids will never get to have that close relationship with her and have grandma come to their concerts at school or their sports and activities, those types of things. It's a tremendous loss. You admitted here, and I believe it's from the very beginning, what you have done, that you have caused the death of Jennifer. You were driving while under the influence and in fact intoxicated. And you've done it before. So it's very serious because you do have that 25 years of initial confinement and 15 years of extended supervision hanging over your head, where the court could say, based upon the facts of this case and the facts of your history and the facts that have been presented to the court, that this is so serious that you could spend essentially the rest of your life in jail, in prison, the rest of your life behind bars. Or the court would have to determine whether or not this is something that doesn't quite reach that level, but maybe something in between. You did accept responsibility by pleading guilty. You saved the family from even more trauma and more pain of going through a trial. That's a positive thing. I say this a lot, and I really wish that it could happen, that if I had a magic wand, I would change everything that happened and bring Jennifer back and make everything good as gold. I'm sure you have the very same wish. Unfortunately, this is reality, and we can't do that. We are here where we are here today, all because of what happened on, I believe it was August 17th, 2024. This is, I don't think there's anything worse than a loss of life, and especially a loss of life that it was predictable, and it was definitely 100% preventable. You have the history of drinking alcohol to an intoxicated level, and operating a motor vehicle. This would be the third, at least third conviction related to that. You should have known better. You should have known that, especially considering 4 months before, and I believe that was April 27th, 2024, 4 months prior to this accident, this unnecessary accident to occur, you did the very same thing, but in a different county. You drank to excess, you drank to intoxication, you drove a UTV, you rolled and crashed that UTV, both you and Jennifer, Ms. Kopinski, were hurt and injured, and you were charged with charges that, for whatever reason, was not a crime, simply a forfeiture, a ticket. But it was the same actions, the same conduct, the same behavior, the same thinking as we have in this matter. The only difference is death. Predictable and preventable. Mr. Schmidt said it a lot in his argument and in his statement to the court, because this is 100% that, predictable, preventable. Especially considering the diagnosis in 2020 with your doctor with the Huntington's disease. I'm not positive. I was not in the doctor's office with you. I didn't receive your medical documentation and recommendations from your doctor, but I've had multiple people in front of the court with Huntington's disease before. So I know a bit about it, and I've learned a bit more now about it from your attorney's argument, which was very insightful. But I'm going to guess, and I'm pretty sure I'm right, that when you were diagnosed with and confirmed that you have Huntington's disease, your doctor told you, do not drink alcohol. Probably not simply, you shouldn't drink alcohol because X, Y, and Z. I'm going to guess your doctor said, you cannot drink alcohol, because I know alcohol speeds up Huntington's disease, the use of alcohol. And especially on the medications that you need to take with it, it increases the effect of alcohol, even though your body, your brain, doesn't necessarily feel that effect. There's no doubt in my mind you loved Jennifer. There's no doubt in my mind. But so did everybody here. You have to live with the loss of Jennifer. Family has to live with the loss of Jennifer, but they're completely different. Your actions caused the loss, and it could have been prevented. I agree with the statement and argument that was made by Mr. Schmidt about this double-edged sword. In reviewing the information in front of the court and by the attorneys for this case, and your statements made, your symptoms are extremely severe. You should not have been driving or contemplating driving at all, unless it's an emergency, and definitely not if you were under the influence. And with the who cares attitude, we only live once attitude, YOLO, it may be okay for you to have that attitude. It may be okay for you to put your life at risk, but you put so many people's lives at risk that day. And every other day you drove intoxicated, whether in a vehicle, whether a UTV, whether an ATV, you put a lot of lives at risk. And a who cares attitude, and we only live once attitude, killed Jennifer. And unless you can change that attitude and live to the fullest every day, even with your diagnoses, you're going to continue to put people at risk. You are continuing to be a safety concern for the community. Because just in the short few years of your relationship with Jennifer, you continuously put her in danger so many times. And based upon the facts and the undesirable behavior pattern of knowing these things, yet continuously doing the things that you know you should not do, driving while under the influence and ingesting alcohol, you put a lot of lives at risk. And there's no reason to believe that you won't do this again unless you make some significant changes. And in a case like this, as your attorney stated on the record, that there is a mandatory minimum of 5 years of incarceration, unless the court finds a compelling reason and states it on the record that it should be less than 5 years. Although I understand you have Huntington's disease, although I understand that it's an extremely serious condition and disorder, and that you're going to have a punishment And even though I now understand a little bit more about Huntington's disease and that you are in the middle stage and maybe in the end stage soon, and that could require continuous care and unable to get out of bed and an early death, I was aware of that possibility. I cannot find Huntington's disease and your position and where you are is a compelling reason to go below the mandatory 5-year minimum. There needs to be deterrence, not only to deter you from engaging in this conduct and to actually compel you to make changes in your life, but the court needs to deter others from doing so as well. I don't know how many deaths we've had in the last couple of years, but it's a lot. It's been a lot. For a small little county, it's been a lot. I love UTVs. I love going on the trails. And yes, sometimes it's nice to stop and have a drink or two. But they are all around us now, all around us, on every trail, in every place. And it is not a party barge. It is not a party on wheels. And perhaps the legislature will look at harsher penalties for intoxicated operation while on a UTV. Because again, things can be prevented. Things can be prevented. The community needs to be protected, and I need to ensure that they will be protected for a significant amount of time, and to have you be given the opportunity to make some changes in your life. With regards to this sentence, count 1, maximum possible penalty, 25 in, 15 out. The court is going to sentence you I have 3 different conflicting, they all are different recommendations. 5 years in from defense, 7.5 from the state, 9 to 10 from the DOC. I don't prejudge. I don't have I may have an idea of what I would sentence at the time of reading the PSI, but I don't have something stuck in my head. And I don't predetermine my sentence, because it's so very important to hear from the state and hear from the defense and hear from the defendant. Based on the recommendations and hearing it again and hearing the arguments today and now rereading and reviewing the PSI, I believe that 10 years of initial confinement with 10 years of extended supervision is necessary. Anything less would unduly depreciate the seriousness of the offense. We have a death, a human life that cannot be replaced, that cannot be brought back. It's a death. Granted, it was not a homicide with a gun or a knife or your hands. It was still a homicide. And it could have been prevented. And because of the mandatory minimum of 5 years, I do find that that is the bare minimum that the court must start with. The fact that this has been occurring multiple times over the period of time that you were with Jennifer, and you put her at risk so many times, her life at risk so many times, which ultimately the Russian roulette game was lost this time. And because of this loss and this undesirable behavior pattern, and I can't believe that it only happened this time in Burnett and that one time in Barron. My gut's telling me there are more times and more times that you were driving that UTV while intoxicated with Jennifer. That's why the court is sentencing you to 10 years of the initial confinement and 10 years of extended supervision. $518 in fines and fees to be paid in payments as determined by the Department of Corrections. Any restitution? No restitution is requested. So the court costs are to be collected as a percentage determined by the Department of Corrections to be reasonable within the state prison as a condition of your extended supervision. Court is ordering your DNA. You can, the jail will make sure that they get your DNA. In this type of case, I do not believe that you would be able to have it expunged from the system. The court is going to make you eligible for the substance abuse program. I am not going to make you eligible until you have a year and a half left on your sentence. That'll be enough time to complete the program if you wish to, and to learn what you need to learn. You are not eligible for the challenge incarceration program. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. If you fail to pay your court costs and fees, the court will not only enter a civil judgment against you because you're always going to owe it, but I will issue a warrant and you can sit an additional 6 months in jail. You're remanded immediately to the control of the Department of Corrections. No use of or possession of a firearm for life, no voting in any election until your civil rights are restored. Again, 20 days to appeal. Mr. Schmidt, what am I missing?
Just that Wisconsin statute 973-01 sub 3G prohibits the court from finding Mr. Thone ever eligible for SAP or ERP on this.
Thank you. I thought that that was the case, but I wanted to ensure that he had some incentive to do it.
For the confinement portion, the court could find it for the ES.
Thank you. Then what I'm going to do is I will strike the year and a half because he has to serve the entire amount of the sentence, and he could be eligible for it on extended supervision. While on extended supervision, no use or possession of any illegal drugs, substances, or paraphernalia, absolute sobriety, absolutely zero alcohol, no bars, taverns, liquor stores, or any place that has the primary purpose for the sale or the service of alcohol, no casinos, regular drug testing, regular alcohol testing, AODA assessment and follow through, mental health evaluation and assessment and follow through. What else am I missing, Mr. Schmidt?
Nothing for me.
Mr. Nelson, what else am I missing?
As far as I'm aware, I think the court's addressed everything it needs to address.
All right, thank you.
Is there any jail credit?
Oh, yes, what is the jail credit?
I didn't get that.
I meant to calculate that and I didn't. I'm sorry.
All right, we do have our lieutenant from our jail who is present here today. I know it is not easy and simple, Lieutenant, to make those calculations, but if you can do so and have it sent to my assistant and I'll put it in the file, it can be a week.
Should have it today.
Excellent, thank you. So we will wait until I receive the jail credit before I enter the judgment of conviction. And then, Mr. Thone, if you object to that jail credit after seeing the judgment of conviction and or the information by the lieutenant that will be placed in the file, you have 7 days to object. Anything else, Mr. Nelson?
No, thank you.
All right. Thank you. Then we are adjourned.
Hearing 2 complete, and we're almost 2 hours into the show. I've lost track of the McNally courtroom, to be honest. So I'll scrub that transcript later, and if there is follow-up on that hearing, because there was the possibility of them coming back, if there is, that will become its own video probably as well, and we'll do it that way. So as you know, I've also been monitoring this situation out of Minneapolis, so my attentions have been divided. Here's a little bit of footage for you that's fairly tame. This is parents finally getting reunited with their children. So what I know so far, and there's supposed to be a press conference at any time on this, but the reason it was initially reported as a church shooting but then changed to a school shooting is they were, the students and teachers, they were in mass. It was supposed to be the opening mass for the school year. Multiple outlets are reporting that 20 are wounded. There are unconfirmed reports that there are 2 dead. NBC News is reporting that the shooter killed himself, so he is dead. And CBS says that at least 10 are in critical condition. So that's what's going on with that. As odd as this sounds as a palate cleanser, but we need something a little bit different. I want to go to Louisiana because they have something that we've never seen out of the parole board before, at least not on this channel. But before we go there, as odd as this sounds for a palate cleanser, let's go to Judge Glazer. Because I need something different.
Next is George Herrera, page 16. Bond out. Look at you, my bearer of great news today. Thank you. That's like 3 of them. Andy Lantres. There's a bondsman here for him, I think. I think I saw a bondsman here earlier.
Mr. Lantres, yes, there's 2 bondsmen here.
Oh, well, that's not my issue, just as long as there's a bondsman here. Good morning, sir. You were arrested. Do you speak English?
Spanish, please.
Sir, you were arrested for felony battery from April 14th of 2025.
Muy bien, buenos días, señor. Usted fue arrestado por agresión física en calidad de delito mayor. Esto data del 14 de abril del 2025.
I will appoint the public defender's office for you.
Le asigno el abogado de oficio para que le represente.
Judge, I did do a stay away order from the club if he's
He
not.
works there.
But I don't know if he's still working there.
Are you still working at the club?
¿Todavía está trabajando en el club, señor?
Sí.
Yes.
Don't do the stay away order from the club.
So, sir, you are ordered to stay away from the alleged victims whose initials are FF and DC.
Señora, usted se le va a ordenar estar alejado de las presuntas víctimas cuyas iniciales son FF y DC.
No contact with the alleged victims either directly, indirectly, in person, in writing, by telephone, or through third parties.
Usted no puede tener contacto con las presuntas víctimas de forma directa, indirecta, en persona, por escrito, por teléfono o a través de terceros.
And no contact with the victim through social media or other electronic means.
Usted no puede contactar a las víctimas a través de medios electrónicos ni los medios sociales tampoco.
And stay at least 500 feet away from the victims, their home, school, and place of employment at all times.
Y tiene que estar a todo momento como mínimo 500 pies alejado del lugar de las víctimas, la persona de las víctimas, centro de trabajo al que asistan o escuela a la que asistan.
Right, so he kicked victim 1 who had a nasal septum fracture.
Entonces aquí se indica que usted pateó a la víctima número 1 fracturándole la cavidad nasal.
Ankle sprain, left shoulder sprain, and a dislocated or herniated disc.
Y entonces además se indica que le causó un esguince en el tobillo, además le dislocó el hombro izquierdo y que además le causó una hernia discal.
Victim 2, he also punched. I'm not sure what victim 2's injuries are.
También golpeó a la víctima número 2, aunque no se indican cuáles fueron las lesiones sufridas.
He punched victim 2.
Le dio un puñetazo a la víctima número 2.
Not sure what the injuries are to victim 2.
No estoy segura de cuáles son las lesiones de la víctima número 2. Un momento, por favor.
He had a ruptured tricep tendon on his left arm.
Esta víctima sufrió una laceración en el tendón en el brazo izquierdo.
There's probable cause for the charges of felony battery. Count 1 is $5,000. Count 2 is $5,000.
Tenemos motivo fundado para esta agresión física en calidad de delito mayor, $5,000 en el cargo 1, $5,000 en el cargo 2.
Have a nice day, sir.
Tenga buen día, señor. Gracias.
Next is Victor Gonzalez, page 16. Oh, thank you. Good morning, sir. You were do you speak English?
Spanish is better.
Sir, you were arrested for possession of a controlled substance called crystal meth and possession of drug paraphernalia.
Muy bien, buenos días, señor. Usted fue arrestado por haber estado en tenencia de una sustancia regulada, dígase metanfetamina en cristales y además adminículos para consumir drogas.
I'm appointing the public defender's office for you.
Le estoy asignando al abogado de oficio para que le represente.
There is probable cause for the charges. It's pretrial services, alternate bond, $2,500, count 1, $500, count 2.
Tenemos motivo fundado para estas acusaciones. Le asigno supervisión del programa de servicios previo a juicio como condición de salida o alternativamente 2,500 en el cargo 1, 500 en el cargo 2.
Have a good, what, Ms. Seth?
Are we, which defendant is this, Judge?
This is Victor, I'm sorry, this was Victor Gonzalez.
Is that the right person? Because look at the picture.
Wait a minute, we don't have the right person. Who is this gentleman here? Thank you.
Un momento que no tenemos a la persona correcta. Un momento.
Andy Gonzalez Perez.
This is a different Gonzalez.
All right, we'll just do his case. He's standing there. Adriani Gonzalez Perez. She has 2 cases. So you were arrested for dealing in stolen property, carrying a concealed firearm, and written threats to kill or do bodily injury.
I'm sorry, Your Honor. Can you repeat for the interpreter?
I'm sorry, Your Honor. Who is the defendant?
You sent him in. It's Adriani Gonzalez Perez.
No, that's not him either.
It is.
This is Adriana,
Look at the
right?
picture.
Yeah. This is
Disregard
Adriana.
the other case.
Yes, this is number 46.
All right, so you have 2 cases, dealing in stolen property, carrying a concealed firearm.
Muy bien, señor. Buenos días. Usted enfrenta acusaciones aquí de haber estado negociando con propiedades hurtadas y además de haber estado portando un arma de fuego oculta.
And also written threats to kill or do bodily injury.
Además de amenazas por escrito de causar la muerte o serios daños corporales.
So I will appoint the public defender's office for you on this case.
Le asigno al abogado de oficio para que les represente en este caso.
So on the written threats to kill or do bodily injury, there's probable cause.
Tenemos motivo fundado para la acusación de haber enviado amenazas por escrito de muerte o graves daños corporales.
He posted a video on Instagram that he's going to do a mass shooting by killing the victim and victim's entire family at a gender reveal party.
Aquí tenemos un video publicado en la red Instagram donde él indica que iba a hacer un tiroteo masivo matando tanto a la presunta víctima como a su familia en la fiesta de revelación del género.
You are ordered to stay away from the alleged victim, whose initials are JC.
Se le ordena estar alejado de la víctima cuyas iniciales son JC.
No contact with the victim either directly, indirectly, in person, in writing, by telephone, or through third parties.
No puede tener contacto con la víctima de forma directa, indirecta, en persona, por escrito, por teléfono o a través de terceros.
And you must stay at least 500 feet away from the victim, victim's home, school, and place of employment at all times.
Tiene que estar a todo momento, como mínimo, 500 pies alejados de la víctima, el hogar de la víctima, escuela a la que asista o centro de trabajo.
Do you understand the stay away order, sir?
Señor, ¿usted comprende la orden de alejamiento?
Sí. I'm setting
Yes.
a bond on this case at $7,500 plus house arrest with a GPS monitor.
Estoy estableciendo la fianza en este caso en $7,500 más arresto domiciliario con un requisito del monitoreo por GPS.
I'll do level 3 house arrest with a curfew, 11 p.m. to 6 a.m.
Tenemos nivel 3 en este arresto domiciliario. Vamos a poner un horario exclusivo de que toque de queda de las 11 p.m. a las 6 a.m.
The other case, he's charged with dealing in stolen properties, and he basically has a stolen firearm they found on him.
2016, Judge.
It's still stolen. It's probable cause for grand theft of a firearm. I'll set $1,000 bond. Count 2, carrying a concealed firearm is $2,500.
Entonces, en el otro caso, señor, usted está enfrentando la acusación de haber estado negociando con propiedades hurtadas. Esto se refiere a que usted estaba en tenencia de un arma de fuego. Indica defensa y fiscalía que esto data del 2016. Indica la jueza que no importa, que sigue siendo un hurto mayor cuantía y por tanto van a ser $1,000 de fianza y además por haber estado portando un arma de fuego oculta, $2,500.
And also plus house arrest level 3 curfew from 11 p.m. to 6 a.m.
Además del arresto domiciliario nivel 3 con toque de queda de 11 de la noche a 6 de la mañana.
Have a nice day, sir.
Buen día.
Was the one I called? I need to call back. Was it Victor Gonzalez on page 16? Can we have the right Gonzalez person? Right, Mr. Gonzalez, come in. Good morning, Mr. Gonzalez. Do you speak English?
¿Habla
Spanish,
inglés?
please. No. You were arrested for possession of a controlled substance called crystal meth and possession of drug paraphernalia.
Muy bien, señor. Buenos días. Usted está enfrentando acusaciones de haber estado en tenencia de una sustancia regulada, de cristales de metanfetamina y haber estado en tenencia de aminículos para consumir drogas.
I will appoint the public defender's office for you.
Le asigno el abogado de oficio para que le represente.
There is probable cause for the charges.
Tenemos motivo fundado para estas acusaciones.
It's pretrial services with an alternate bond of $2,500 count 1 and $500 count 2.
Le voy a otorgar salida con supervisión del programa de servicios previo a juicio con las fianzas alternativas en el cargo número 1, $2,500 en el cargo número 2 de $500.
Have a nice day.
Tenga buen día.
Next, I'm not sure who's next. I mean, is it Jacob Brown? Jacob Brown next?
Yes, he's on probation.
Thank you. Hold for F24 14967. Good morning, Mr. Brown. You were arrested for retail theft with a prior conviction. I will appoint the public defender's office for you. You're also out on probation. There's a hold for you to see the division judge tomorrow for case F24 14967. So this goes back to yesterday. He's stealing merchandise from Beal's store. You are ordered to stay away from the Beal's store at 150 Northeast 8th Street in Homestead, Florida. You are not allowed to go to that store and you must stay away from there. So let's see. Now your review.
Page 3 talks about the stolen merchandise and the convictions.
There's probable cause for the charges, so he has to hold. Does he have a lot of power? Yeah. I'm setting a bond as $2,500. Have a nice day, sir. Next is Brian Casas on page 17.
Not a charges.
Thank you. Good morning, Mr. Casas. This is a case from August 5th. You're charged with strong arm robbery and false imprisonment. I will appoint the public defender's office for you. probable cause for the charges. You are ordered to stay away from the alleged victim, Kelly Brito. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact. I'm sorry, did you need the interpreter? No. No contact with the victim through social media or other electronic means, and you must stay at least 500 feet away from the victim, her home, school, and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. Do you understand the stay away order, sir? Oh, and you can return to the victim's residence. If she's still living there, then you got to move out. I did it. But if she's not living there, you can go back. But if she's living there, you can only go to the victim's residence one time only within 48 hours of your release from jail. You must be accompanied by a police officer so that you can retrieve your personal clothing, health items, medication, personal and business-related paperwork, and work tools. If you go to the victim's home without the police, or if you stay there, you will be arrested. You understand all that? Okay, thank you. Count one, strong arm robbery. Oh, you almost said it, 5,000? $5,000, count one. Count two, false imprisonment, $2,500. Have a nice day. All right, I passed a case for a gentleman waiting on his attorney, David Figueredo. And another case for Jose Nasco Machado. Do you have David Figueredo, please? I'll have to reset it.
Judge, my staff called multiple numbers that Mr. Figueredo gave to him for the lawyer and was not able to get in touch with anyone.
Okay. Sir, the lawyer couldn't, you speak English?
Yes.
The lawyer, the PD's office couldn't reach your attorney. You want to waive the lawyer's presence so I can set a bond, or I can reset it for the afternoon and you can try and reach your lawyer. Whatever you like.
Okay, say that again. What would the bond be?
Oh, I don't know, whatever I decide it to be. You can
Oh,
either waive the lawyer's presence ahead of time now, or I can reset it in the afternoon and you can call the lawyer up. It's a
Okay.
second-degree felony. Probably it's, so the suggested amount is 7,500, but I can set whatever I choose.
Okay.
If you want to waive the lawyer's presence, that's fine. If not, I'm happy to reset the case in the afternoon to give you a chance to have a lawyer present. This is the first appearance hearing, and it's for the court to determine if there's probable cause for the arrest.
Okay. So let's go. Will I have the opportunity to, like, if I don't reach him in the afternoon, will I have the opportunity for the bond?
Sure, we can do it in the afternoon if you like, whatever you like.
Okay.
You want me to reset the case in the afternoon? I will. And
the thing is, I don't know how to even reach him. I'm not.
I don't
allowed
know, sir, I can only tell you, they got phones there. The lawyers tried, they couldn't reach him, but I'm happy to reset the case.
Set me up with the bond. I gotta get out of here. I gotta.
Okay, so sir, I meant, just so we know, I'm finding probable cause for the charge. I'm ordering that you stay away from the alleged victim, your son. No contact with him either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means, and you must stay at least 500 feet away from the alleged victim, his home and school at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs. And do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. And in the event there is an open case in dependency court arising from the same set of facts and events as this case, then any and all orders entered in dependency court regarding your contact, visitation, and custody of the child shall supersede or replace this court's order.
Okay, can I ask?
Do you understand the stay away order?
Yes, I understand everything.
So I was gonna ask the state what bond they're asking for. It's pretty egregious facts, but I don't know. He's obviously has some alcohol issues. He has no priors. You don't want to agree to 5,000?
Requesting standard.
All right. Yes, sir. What is your question?
No, just simply, I don't have any issues. I just wanted to make sure that I could get out of here. So
You
I
can. I'm gonna set a bond and then you can post the bond. Make sure to speak with your attorney. I think the arraignment's gonna be in 30 days. I'm sorry, it's gonna be in 60 days. I'm not sure. But you want to discuss that with your attorney, okay? I'm setting a bond at $7,500 and the court is making a probable cause finding for the charges. Good luck to you, sir.
Thank you.
Thank you.
Okay, they had their press conference in Minneapolis. The details are a little more clear. So apparently this gunman was outside of the church and shot through the windows, and unfortunately struck two children, one age 8, one age 10. Both of them are dead. There are 17 injured. 14 of the 17 are children, and 2 of them are in critical condition. And again, the gunman ended his own life once he was done wreaking his havoc. So that's what went on there. So I want to go to Louisiana. I didn't even know they did this, but they are doing deportation eligibility hearings. So this is a new one on me for this board. So let's check it out and see what that's all about.
Xuất hay không?
Okay. My name is Steve Prater, serving as chairman today. My colleagues on the panel today are Danny Barra on my left and Pete Freeman on my right.
Tôi là Steve Prater, tôi sẽ là người điều phối về phiên tòa ngày hôm nay, và đồng nghiệp của tôi là Danny Parash và Pete Freeman ở ngồi bên phải tôi và Danny bên trái.
The panel today is at the Department of Public Safety and Corrections headquarters in Baton Rouge, Louisiana. Headquarters staff, please introduce yourself for the record.
Robert Williams. Whitney Trostler.
Francis Abbott.
Okay.
Và ở đây là bên cơ quan về an toàn công cộng và phụ trách về vấn đề giám sát ở Baton Rouge ở Louisiana, và các nhân viên sẽ giới thiệu bản thân họ.
Okay, would you please introduce yourself, the inmate, because I don't believe I'll be able to say your name properly. Would you introduce yourself and tell us your DOC number?
Và những người phụ trách.
Home Banner. DOC number 277377.
All right. I will give you a brief explanation of the process. Act 158 of the 2025 Louisiana Legislative Session created a process for rendering certain detained non-citizens eligible for release exclusively for deportation. This process requires approval of Governor Jeff Landry, the district attorney involved in the prosecution of the current offense of which you're serving, and a review and determination by the Committee on Deportation Eligibility. Should this committee approve you for the removal process, your sentence will be suspended and you're transferred to ICE custody for the purpose of deportation. Once deported, you must remain outside the United States with no re-entry unless fully compliant with federal immigration law. If you re-enter the United States illegally, parole is automatically revoked and the suspended sentence must be served in full. If you're not approved for deportation, you will return to the custody of the Louisiana Department of Public Safety and Corrections. We will give you an opportunity to make a statement. We'll allow public comments. 3 supporters will be allowed to speak on your behalf, and 3 people in opposition will be allowed to speak. Any public officials involved in the arrest and prosecution of the crime can give their statement. Then we will vote. Your case, in this case, has been assigned to Mr. Pete Freeman, who will take the lead on the interview. So if we could have the interpreter explain that, please.
Tôi sẽ cho biết một cái giải thích ngắn gọn về quy trình này theo đạo luật 158 vào năm 2025 của tư pháp Louisiana, được thành lập trong một số trường hợp mà những người bị bắt giam không phải là công dân Mỹ có điều kiện để có thể được thả ra để mà trục xuất, và quy trình này được yêu cầu bắt buộc phải có sự đồng ý của thống đốc Jeff Laundrie và bên công tố viên, tổng công tố viên trong cái quá trình truy tố và những cái tội danh hiện tại mà quý vị đang bị bắt giữ và xem xét và quyết định bởi hội đồng xem xét để trục xuất, đủ điều kiện trục xuất hay không, và nếu mà hội đồng chấp thuận cho trường hợp của quý vị thì lúc đó là cái bản án của quý vị sẽ được tạm dừng và quý vị sẽ được chuyển qua bên giám sát của ICE là bên cơ quan di trú để trục xuất. Và một khi đã bị trục xuất thì quý vị phải ở ngoài Hoa Kỳ và không được trở lại Hoa Kỳ, ngoại trừ trong trường hợp tuân thủ theo tất cả các luật về di trú của liên bang. Nếu như quý vị trở lại Hoa Kỳ bất hợp pháp như vậy thì cái lệnh tạm giam này sẽ tự động bị hủy và những cái án treo sẽ được chuyển thành án tù và phải thụ án đầy đủ. Nếu như quý vị được chấp thuận để trục xuất và quý vị sẽ trở lại, nếu như quý vị không được chấp thuận để trục xuất thì quý vị sẽ bị tiếp tục giam giữ bởi cơ quan an ninh của Louisiana về an toàn công cộng. Và chúng tôi sẽ cho quý vị cơ hội để đưa ra lời phát biểu của mình, và quý vị cũng được cho phép đưa ra những cái lời khai công khai và nhận xét. Thì quý vị sẽ có 3 người được phép có thể nói đại diện cho quý vị và 3 người phản bác, thì tất cả đều được cho phép phát biểu. Và đối với những nhân viên công cộng, những nhân viên công nào liên quan trong vụ bắt giữ và truy tố tội danh mà quý vị đã phạm thì cũng có thể đưa ra lời phát biểu của họ. Rồi sau đó chúng tôi sẽ bỏ phiếu để biểu quyết xem quý vị có được chấp thuận hay không.
Okay, Mr. Freeman.
Okay, Mr. Pham, please state your name again and your DLC number.
157277377.
Okay, Mr. Pham, would you like to make a statement on your behalf or any statement to this committee?
Well, sir, I got this paper from the Department of Correction yesterday. I signed for the original copy. I had a copy of the original sent to me 3 days ago. Prior to that, ever since I got the paperwork, I hadn't had no chance to contact none of my people or anybody to represent me in any kind of way in front of the board. I had, as of right now, my family don't even know where I'm at. And I've been through the process before. What happened last time was I was sent over there to Oakdale too. And the process takes 6 months. And I had to stay at Oakdale too.
Okay. So there's no one here to speak. You have an attorney?
Frozen up.
I had David noted, but I had noticed it. I had no way of contacting them. I wasn't allowed the phone. They say the phone wasn't operable. No, as of right now, my family don't even know where I'm at since I got shipped over here.
All right, is there an attorney on his behalf there? Okay, no one in opposition, I'm ready to vote.
Okay.
Okay, I think we've heard enough to prove that you are an illegal immigrant. I grant your parole to an ICE detainer or deportation proceeding.
Okay, that's your vote is that he be granted parole.
I concur, grant to ICE detainer.
And I concur also. Today you've been paroled to go straight into an ICE facility for deportation from the United States. We appreciate you not coming back. Let you do so legally. Thank you.
I'm not going to play a denied or an approved because I'm not sure which one fits, to be honest with you. Interesting. So they have more of those going on, so we might catch another one. But let's go to Judge Boyd. She's had a weird day. She was almost 2 hours on the bench before this person finally approached. So she's had like nothing to do until now.
R 5976 State versus Rodney Brown. Can I have parties announced?
Jason Garahan for the state, Your Honor. Gary Baker for Mr. Brown, Your Honor.
And are you Mr. Brown?
I am.
All right, could you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Rodney Brown.
All right, so why didn't you appear for court?
I woke up late and I contacted my lawyer and he told me that I had until 4. And at around like just before noon, he told me that the warrant was already issued. And to be perfectly honest, the person that I was in a relationship at the time had showed me a series of videos of your more tougher representations of the and I didn't know. I've been here the last 3 days. I came into your court, I sat in the court, and I've listened to you and talked, and it was a misrepresentation of who you are. You And can be tough. That's I okay. know, I know you can be tough, It's a but mess. the people in these videos, you know, had to be taken into consideration the context, and it was shown to me out of context. And I was during that time taking anxiety meds there, and I wasn't getting the proper care. My doctor was actually kind of a bit of a pill pusher, and so I was just going through a lot, and my family was not in a stable situation. So at the time, I got nervous, and I was like, I need to take care of my family, make sure my family's good, and then once my family's good, I'm willing to turn myself in and take care of whatever needs to be taken care of. At this point, my family is in the best possible situation. So,
Well, what I can tell you is when I was a defense attorney, I would represent clients, and sometimes clients would say, well, I'm sitting here and this person did A, B, and C, and they're out and about. And I always have to remind them, you have to take in consideration what court they're in, what the facts of their case are, because you really don't know. And people can chop things up and make things seem different than what they are. Because I will tell you, there are some people who will come to me and they will say, just different attorneys, oh my gosh, people wearing shorts getting taken into custody. And I'm like, no. I said, that was secondary because you shouldn't wear shorts in court, but you're not allowed to take photos of or talk to inmates when you're in the gallery because for security reasons, that's not allowed. But it's easily to chop that up and thinking, oh my gosh, you're taking somebody in custody. It's just a regular citizen wearing shorts.
yes.
So there are different things that happen. But in this court, what I can tell you is hopefully I'm fair to everyone. I try to be fair to everyone. And I look at people as individuals. In each case, I don't remember people's by their numbers or case number, but I remember the person as an individual. And I remember the stories that they've told me before. That's how I remember things. And that's how I was taught to know case law, because it's easy for me to remember cases because I remember something that's sort of weird about the case and the case law. That's how I remember it. Now, sometimes I can't tell you, oh, that's Jones v. State. But when I read a little synopsis, I'm like, oh, yeah, I know that case. All right. So in this court, let me just tell you, you need to come to court and you need to be on time. In this court is at 9 a.m. If it's not at 9 a.m., I will let people know, hey, we're starting at 1:30 and give people a reason. So you say that you are receiving mental health care or something, or?
I was receiving mental health care. The last time I went, I was being completely honest with her. I had a lot of stresses in my life, and I told her that the medicine wasn't working. And instead of addressing it, she just kind of switched me to another medicine that the pharmaceutical sales rep had dropped off that day. And when I went and did some research, it was not an appropriate switch. And so I actually got myself off the medicine. I started exercising and taking a more positive outlook on life, and so I've grown a lot in the time that I've been released.
All right. And then has there been any type of drug use in the past?
No.
All right. So have you all agreed on a bond?
Yes, Your Honor, previous bond was set at $7,500.
And was that a PR bond?
It was a PR bond.
So are there going to be any objections to reinstating the PR bond?
We were asking for the bond to be made, Judge, but I know defense counsel is asking for the PR bond to be reinstated.
All right. So then the question becomes whether or not he can afford bond. I'll note that this doesn't appear to be an alleged violent offense.
That is correct. It's not a violent offense.
All right. So do you want to put any evidence on about
Sure, I will. Put my-
the amount he can afford?
Yeah, sure. Should I?
Yes.
Yeah. Well, he's been sworn. Okay. Sir, what is your current employment situation?
I'm currently unemployed, but I do have an employment opportunity as soon as I present identification.
As of right now, do you have any money in the bank, cash and savings accounts, checking accounts, CDs, or any investment accounts? Anything?
I do not.
Okay. Is it fair to say your dollar amount to your name in any holding institution is zero at this point?
It's negative.
Negative. Okay. Do you own any property?
I do not.
Okay. Do you have any? Some people might not have any money in bank, but they've got a Ford Raptor in the driveway or some other asset that they could sell to raise the $7,500. Do you have anything like that?
I do not.
What about family? Is there family that could help you to pay the $7,500 bond if the court says that?
They will not.
Okay. Do you have any other way to be able to afford that bond if the court closes it?
Outside of earning the money myself, once released, if there's a way to, no.
But presently you don't.
Presently, no. I have my account for the county is in a negative, and I have $7 on my phone in order to speak to my mother. That's the only person in my life. She's on the East Coast, and she's taking care of my brothers.
Okay. She doesn't have the funds either to.
No.
And you have court-appointed counsel in this case. You've been previously and remain in that state at this point.
Yes.
Okay. I don't have any further questions.
All right. Any questions?
Previously to being incarcerated for the bond violation, what was your employment status before that?
I was in between jobs. I had recently been released from North Italia at the Rim, and I had applied to Hawkins Personnel Group, and they told me that if I brought in identification, a picture ID, that they would employ me.
What do they do? I'm sorry.
It's a temp agency, and they said that I could work at the Fiesta warehouse. I think it's like more downtown. Monday through Thursday. Friday is optional. It'd be overtime, and pay rate's about $15 an hour. And the only thing that stopped me from reemploying was that they did e-signature, which required a picture ID. I had my voter's registration card and my birth certificate, which should have been enough, but because of the e-signature, they told me as soon as I get ID, I'm really good.
Okay, thank you. No further questions.
All right. So this is what the court is going to do. The laws for setting bonds have changed, right? So I can either set you a bond at $3,500, or I can do the PR bond at $7,500. I'll ask that the fees are waived, and you'll have to be placed on GPS, and that'll be GPS partial for employment. Those are your only options. My hands are tied as far as.
He will take the second, Your Honor. We actually already discussed that. I forgot to mention that, but he understands that he'd be monitoring that situation.
All right, so there's going to be a PR bond, $7,500, waive fees, and then there's going to be partial GPS for employment only, and I'll ask that the fees are waived. You do have a place to live, correct?
That would have to be verified. My plan initially was to be released to the Haven for Hope, or whenever I was released, to use my resources and not to be a further burden on my family.
All right, so this is with the GPS, he'll need to have a phone. So counsel, I'll need you to keep updated and let me know before today is Wednesday, probably let me know by Friday if there's going to be an issue
You can get
with,
one. No problem. I can get a complaint.
but you'll have to have a specific residence.
Specific residence. I'd have to talk to them.
Just a second.
Just because I'm out, so you're.
Probation. Do y'all know, are you allowed to have GPS at Haven for Hope?
Your Honor, the full address on file. Would it be?
I have a home address. My father's lived at 15403 Spring Summit.
Oh, no, you don't need to tell me the address, but I'm just letting you know you need to have a home address for GPS. And counsel, if you will let me know on Friday if there's an issue, we can take that up.
Okay, Judge, I will speak to him and see if I can make sure he has it.
All right, and where are we on discovery? I think discover and offer tender.
Yes, Your Honor.
Yes, Judge. I don't intend to bring a motion on this or anything like this, but the court may recall this happened at the magistrate's court. I'm brand new to the case. I was appointed. Okay, and no requests were made for the cameras there. There is no body cam of the arrest or anything like that for the incident we're talking about. And I believe there was the DA's representative. There are cameras at the magistrate's office, but they don't keep them this long, and we all presume that that's now been destroyed. For purposes of trial, I would like them to verify that so that I can make that argument if it's appropriate and the court allows.
All right, Norma, if you extend the plea deadline date to the 3rd week in September, please. All right, so state, if you all can see if there's some video of this.
My understanding is it was looked into. And
Okay.
This is a 2023 case.
Ah.
And it's been purged by now, Judge. So
Okay.
it was looked into previously. And so there is some body cams, which Mr. Baker probably just addressed about after the actual finding of, not to give you all the specific facts. Yes.
So do you need the plea deadline date extended?
Judge, that would be helpful, especially if my client ends up released. I can speak to him in better circumstances because I think we're close.
Okay. All right, Norma, if state you have no objections to extending the plea deadline date?
No.
All right, Norma, if you can extend this for that 3rd or either 4th week in September.
The 23rd.
All right, and make sure he has a reset form. You need to be in court at 9 a.m. Do you understand?
Yes, sir.
All right, thank you.
So we were with Judge Glazer before this, and I had forgotten to mention, she's gone to lunch, by the way, so good for her, keep the hangry away. But I had forgotten to mention that they had her back in her regular courtroom yesterday. They'd, from what I can gather, been doing technology upgrades in the courtrooms, and that's why she was in a couple of different places. But they had all sorts of audio issues yesterday from that courtroom, which is why I did not show her. There was like this echo. So today they actually had her back in the temporary courtroom. So there's all sorts of weirdness going on in Miami-Dade too. Let's go back to Louisiana. Looks like we're going to try this again with a new contestant.
The Committee on Deportation and Eligibility we're in Baton Rouge today, and you can see who it is that's going to be hearing your case. We're going to be talking about your parole eligibility. My name is Steve Prater, serving as chairman today. My colleagues on today's panel are Danny Barrett, Barra on my left, and Pete Freeman on my right.
Xin chào, tên tôi là Steve Power và tôi sẽ là người chủ tịch ngày hôm nay, và các đồng nghiệp của tôi ngày hôm nay trong hội đồng xét duyệt là Danny Power ở bên trái và Peter Furman ở bên phải. Chúng tôi sẽ xem xét về trường hợp trục xuất của ông.
Let me ask, can you understand English?
Yes.
Yes?
Yes, sir.
Okay, we won't need the interpreter on this then. Just listen to me as I go through this sheet quickly, and I don't know if you have a copy of it or not, but listen to it. I'm gonna go pretty quick with it, but it just is telling you what the authority we have to parole you today, or not parole. whatever our decision will be. Okay, listen closely. I'll give you a brief explanation of the process. Act 158 of the 2025 Louisiana Legislative Session created a process for rendering certain detained non-citizens eligible for release exclusively for deportation. This process requires approval of Governor Jeff Landry, the district attorney involved in the prosecution of the current offense for which you're serving, and a review and determination by the Committee on Deportation Eligibility. Should this committee approve you for the removal process, your sentence will be suspended. You'll be transferred to ICE custody for the purpose of deportation. Once deported, you must remain outside the United States with no reentry unless fully compliant with federal immigration law. If you re-enter the United States illegally, parole is automatically revoked and your suspended sentence must be served in full, everything. If you are not approved for deportation, you'll return to where you are now, in prison. Okay, we'll give you an opportunity to make a statement. We will allow public comments. 3 supporters will be allowed to speak and 3 people in opposition. Any public officials involved in your arrest and prosecution will also be able to speak. Okay, your case has been assigned to Mr. Pete Freeman on my right. So why don't you answer any questions or whatever he might ask of you?
Okay, can you state your name and DOC number again, please, sir?
My name is Hin Sin Ho. And DOC of 578-488.
Okay, that's correct. Okay, Mr. Ho, what kind of statement would you like to make to the board on your behalf? Is there anything you want to tell us?
The only thing I'm concerned is like, I know the ICE want me anyways, and I had to go there and for deportation. But the only thing I'm concerned like is the process is different.
Yes, sir, that's because of a new law.
Okay, well, wait. Hold on, you're muted. We can't hear you.
Can you hear us?
Yes, sir. Yes, ma'am. Okay, continue, Mr. Ho. Can't hear him.
Crystal, something's going, Ward Simon, something's going on. We can't hear him.
Okay, have a seat now. Go ahead and say.
Yeah, the only thing I'm concerned with the process, can you hear me now?
Yes.
Yes, we can hear you, sir.
And it don't take couple days or week, it probably take a month to do the process. So how about those times how is that gonna work for both sides?
It works for both sides because if we prove that you're an illegal immigrant and we feel that we should deport you, we grant you parole to the detainer. So they're gonna take care of the detainer now.
I understand that, but yes. But they detain on why I have waited for detaining. I don't want.
Yeah, but
It's affecting.
Let's just, y'all ready to vote?
okay, your sentence just paused, it stops. So your sentence stops today if we grant. But if you come back to the United States, it comes right back up.
Okay.
The whole thing.
The whole thing. Okay.
So I mean that beside that, I don't really have anything to.
Okay, I see no supporters and I see no opposition. My vote today is to grant parole to your immigration detainer for deportation proceeding.
I concur. I grant to the ICE detainer.
And I concur also. As of today at 9:32 in the morning, you have been granted parole under the condition that you be turned directly over to and immediately to ICE, federal government, for deportation. That's the end of this hearing. Thank you.
Okay, well, that got cleared up a little bit. We said we hadn't seen this before, but apparently it's a new law. So now we know. Michael, I think we're going to need a deported or something like that to be able to play for these, because I think we're going to be seeing more of them because they seem pretty serious about it. Let's go to the Wayback Machine a little bit. This was from earlier this morning, Wade Mercer in his first appearances. We hadn't been able to check him out yet.
Mr. Robinson, good morning. Mr. Robinson, you have about 5 different family members here, grandmother, auntie, sister, some family members here on your behalf in the courtroom. You're here because you've been accused of 1 count of battery. Mr. Robinson, I've read the complaint. There is probable cause for the charge. When I looked at your criminal history, it looks to me like you have no prior criminal history. Mr. Robinson, have you ever been arrested or charged with a crime anywhere?
No, sir.
That's great. Mr. Robinson, I'm going to listen to the attorneys and I'm going to address your bond or your release status. Mr. McDaniel.
Your Honor, we just asked for consider conditional release.
Mr. Mitchell.
No objection to a conditional release.
So, Mr. Robinson, given your lack of history, I'm going to let you pick between a bond and a conditional release. Anytime I offer somebody a conditional release, I give them a bond option. Some people prefer a bond, but if you want to choose the bond, it's $2,500 cash or surety. I am going to offer you a conditional release because your history is perfect. You won't have a condition of no contact with the alleged victim either way, so no contact with her. Now, I always try to be clear. You have a child together, correct?
Yes, sir.
I'm not keeping you away from that child at all. I'm only keeping you away from that person. So if there's a friend or family member that can act as a go-between to exchange visitation, that's perfectly okay. You just you can have no communication with her of any type, and you can't send messages to her. But as far as someone picking up the child and bringing the child to you or whatever, if y'all work something out like that through a third person, that's fine. Just kind of keep you two apart at least till this thing simmers down a little bit, calms down. Mr. Robinson, do you want to choose the bond or the conditional release, or do you have questions?
I'll do conditional release.
We're going to grant you that. We're going to also, when you get here, the conditional release officer will give you a notice for your next court date. They'll give you that notice in writing, and that'll be September 29th at 9 a.m. will be your arraignment date. They'll get you to sign for that notice, Mr. Robinson. They'll give you a copy of it. You will not get a notice in the mail. That notice they're going to put in your hand will be the only notice you get. Let me see if your family members have any questions. Any questions, ladies?
Yeah, I have a question.
Okay.
Does he live with me?
Okay.
Okay, so the baby mama, she swears like she can do whatever she wants to do. That's how this happened yesterday, because you pops up at my house and mess with him. So what can I do to keep her from my house? She already done put holes in it, but he ended up going to jail. I asked the deputy, what can I do to press charges on her? Because you done came and messed up my house. Okay. But he tells me I can't do nothing. I can't press charges on her. But she's gonna pop up at my house. Now, she used to stay with us when she was pregnant with the little girl, but the bickering, she was bickering too much. So I, made her leave. She haven't been to my house in like over a year.
Do you live in an apartment or a house or?
I live in a trailer, 4138.
Okay. So if you live in a mobile home, if you live in an apartment, it's a little complicated because the property owner's got to be involved. If you live in a mobile home, you have the right to get a trespass warning against anybody you want to and keep them away from your home.
Okay, so how can
you have to contact the law enforcement agency that has jurisdiction over that property, that area, and then they give a trespass warning. And the trespass warning says you cannot go back over here.
Okay.
Now, if it's in the city, it's got to be the police department. If it's in the county and not in the city, then it would be the sheriff's department. And they will actually physically serve her or tell her, do not go back on this property. Here's where it gets complicated. If there's someone else in the home that invites her over there, that's a problem. So everybody's got to be on the same page. So does Mr. Rollinson live there?
He lives.
Okay, so in other words, if you say, I don't want her here, but Mr. Rollinson invites her over there, what you're doing is useless.
Right.
So you got to have everybody on the same page. Okay? Yes, ma'am.
Davon Robinson, grandmother. I stay in Alabama, and over the years since my daughter died, I'm so proud of him. He got him a job. He ain't one of the reasons he trying to raise his kid.
Good.
But it's just her, and I'm proud of him.
Good.
He go to work every day.
Mr. Rollinson, where do you work at?
Wendy's.
Where?
Wendy's on the interstate.
Wendy's. I can't understand. Oh, Wendy's. Okay. So, Mr. Rollinson, I see people that have friends or family here, but at first appearance, that happens several times a week. But the number of times I see 5 people show up for one person, I could probably, in a year, I could probably count those number of times on one hand. So the fact that you got 5 people that care enough about you to come to first appearance for you says quite a bit. So Mr. Robinson, you've got a lot of family support. That's a great thing to have. So what's going to happen next, Mr. Robinson, is you're going to be brought to the courthouse because that's where the conditional release office is at. When you get here, you'll meet with Mr. Goodson or Mr. Ham with that office. They'll go over the conditional release with you. They'll give you a chance to ask questions, Mr. Robinson, and then they will give you that notice I've already mentioned. They'll give you a copy of all the rules in writing, and then you'll know when your next court date is, and you'll be free to go. So, ladies, he's going to be able to be picked up, and it usually takes 30 to 45 minutes to get here from the jail, get him processed out and back in his regular clothes. Is someone going to be able to pick him up? You got transportation covered. Your family said someone will be here to pick you up, Mr. Robinson. Any questions?
No, just tell him I love him.
All right. Have a good day, sir. So he'll be downstairs in 30, 45 minutes, ladies, okay? Thank y'all for coming. Kenneth Moore. Mr. Moore, good morning. Mr. Moore, you're here because you've been accused of violating state probation conditions. There's a no bond warrant. I'm looking at a copy of it signed by Judge Garcia. Mr. Moore, what I want to do today is I'm going to go ahead and get you arraigned because I've got an affidavit filed by the probation office. If you would like to have an attorney appointed, we can do that today. Do you want to have an attorney appointed to represent you in this VOP?
Yes, sir.
I'm going to appoint the public defender's office to represent you. Listen to Mr. McDaniel, and then I'll see if you have any questions in just a minute.
Your Honor, we're under a plea of not guilty. Yes, to set this on October 9th, pretrial docket, and I've already advised Mr. Green to come visit him prior to that hearing.
Thank you, Mr. McDaniel. Mr. Mitchell, anything?
No, Your Honor.
So October 9th will be your court date, and your attorney will see you before the court date. Any questions?
Yes, sir.
Have a good day, Mr. Moore.
Yes, sir, you too.
Thank you. We have John Cartwright. Mr. Cartwright, good morning. You're here for first appearance. You have a warrant out of Holmes County. It looks like it's a no bond warrant where they've accused you of violation of probation over there. Mr. Cartwright, what that means is you're going to be transported to Holmes County. When you get there, you go in front of a local judge. That local judge will address your bond. Right now, the warrant we have says no bond on it. Mr. Cartwright, sometimes you'll go to Holmes County the same day because they're just 2 counties over. Actually, they touch Jackson County, the northern part of the counties, I think. So you may get over there today, but it would not be unusual if it's tomorrow or the next day. But when you get there, you go to another first appearance. Any questions?
No.
Have a good day, sir. We've already seen Mr. Rawlinson. That brings us to Lance Parikh, and I may be mispronouncing that. How do you say your last name, sir?
Parikh, you said it correctly.
All right, great. Mr. Parikh, you're here on an old failure to appear case. It's a 2012 charge of driving while license suspended. I saw several notes where you've been calling, trying to get away over here to get this matter resolved. And it looks like you finally, I'm assuming you turned yourself in to get this thing resolved. Is that right?
Yes, sir.
Thank you for doing that, Mr. Parikh. I'm going to appoint the public defender's office to represent you, and I'm going to ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to Mr. Perry. He's under a plea of no contest to the charge as listed in 12161 CT. Understanding adjudication be withheld, be 10 days in the county jail. He can purge out of that jail sentence by paying the sum of $400 at the clerk of court. He has 1 day jail credit. He has signed his plea waiver form, waiving his right to a jury trial and call witnesses.
Thank you, Mr. McDaniel. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor, but I do need to know, how tall is he right now? I'm curious.
6'8".
How tall are you, Mr. Parikh?
6'8".
Yeah, our camera just about gets about to your forehead. We can't see the very top of your
right
head.
there on the forehead.
So, Mr. Parikh, any questions about that agreement, sir?
No, sir.
Probably too fancy.
And is that the plea you would like to enter to resolve this whole case?
Probably too fancy. No. Okay. Go ahead.
Is that the plea you'd like to enter?
Yes.
Mr. Parikh, I'm going to accept your plea of no contest to the charge of driving while license suspended or revoked knowingly in case 2012-161 CT. Withhold adjudication of guilt, sentence you to 10 days in jail. But in light of you turning yourself in, Mr. Parikh, you can purge that sentence and be released at any time before completing the sentence. The purge amount is $400, Mr. Parikh. Mr. McDaniel probably told you this. I feel confident that he did. The purges are made at the clerk's office, and they've got to be made while they're open. They're open 8 a.m. to 4:30 p.m. Now, the reason I'm telling you that is I don't want your friends or family to try to make a purge at 5 o'clock today, and you have to spend another 9 in jail. So when you use the phone in a little while, make sure you tell your family, go ahead and make the purge as soon as they can, certainly before 4:30, so that you can get out today. Do you have any questions, sir?
No, sir.
Wish you the best.
Okay, thanks.
Thank you. Mr. McDaniel, anything else from the public defender?
No, Your Honor.
Corporal Drown, jail.
Okay, I think that wraps that up. I want to show you guys something because I'm constantly, well, not constantly, but lately being asked about, well, what feeds are in Arizona. Well, I'm not going to play the audio because there's this crazy HVAC sound that kind of overtakes everything. But this is from Payson, and it's what I've come to refer to as the justice window. There's this like extreme camera angle, just trying to describe this for listeners on the podcast side. There's this extreme camera angle looking up at the defendant, and the judge is in the little corner window where he's delivering, whatever sentence or whatever. But it almost looks like the way it's shot, it looks like they're approaching, like I said, like this justice window where they just kind of walk up and get their sentence and sign their paperwork and then move on. It's really bizarre. But yeah, I'd play it for you, but it just sounds like HVAC with some murmuring behind it. So let's go to Kansas. This is Judge Webster's court, but it's not Judge Webster. It's guest judge number 7. Looks like Judge Murfin. Never heard of him. Let's spend the last 10 minutes with him.
En ese caso, usted tiene responsabilidades con algún hijo que usted tenga que enviarle dinero.
Sí.
Yeah.
Approximately how much of your earnings go to the support of your children?
Y aproximadamente, ¿cuánto usted gasta en la manutención de sus hijos?
Aproximadamente $250.
Approximately $200 or $250.
Okay. And approximately how much do you pay for rent, sir?
Señor, aproximadamente ¿cuánto le toca pagar de renta?
$300.
300.
Okay. All right. Well, I think you're kind of at the threshold, but if you're talking about varying income and with the expenses you've indicated, I am going to appoint counsel for you.
Usted está justo en el límite, pero tomando en cuenta sus ingresos y sus gastos, le voy a poner un abogado asignado por la corte.
Okay. I'm going to appoint a Butler County attorney named Darren Patterson.
Le voy a asignar el abogado del condado de Butler, llamado Darren Patterson.
His office number, if you could write this down, sir, is 316.
Le voy a dar el número del abogado para que lo anote. El número es...
Un momento, por favor.
One moment, please. El número es el 316.
Sí.
322. 7700.
Okay.
I'm going to order that you reappear here on November 5, 2025 at 9 a.m.
Entonces, la orden será que usted se vuelva a presentar acá en la fecha 5 de noviembre del 2025 a las 9 de la mañana.
And Your Honor, forgive my brief interjection.
5 de noviembre.
Go ahead, Mr. Regier.
Just asking your Regier.
Your Honor, it is the state's understanding that traditionally the public defender prefers case defendants that he's involved with to arrive at on or about 8 a.m.
At 8 a.m., you say?
That would be the state's understanding, Your Honor.
All right. I will order then that the defendant appear at 8 o'clock, but the case will likely be called at 9.
In Your Honor,
Yes.
just one more thing. It should be on a Monday, so November 10th instead of the 5th.
Okay. And forgive me, I was looking at an interpreter docket notation, and I have apparently set it for the wrong date. So November 10, 2025, arrive at 8 for a 9 o'clock hearing date.
And Your Honor?
Yes.
Forgive me, if the court is considering a prospective interpreter docket, the state understands that Counsel Patterson does appear on those from time to time, and those are traditionally set on a Wednesday at 1:30.
Okay. Well, and I might, because I'm covering this maybe for the first time, or at least the first time in a long time, Miss Destiny, give me a little help as to which docket this would typically go on from the clerk's perspective.
That's fine, Your Honor. We can do either one. If we'd like to set it on a Monday, when Mr. Patterson usually appears with his clients, then it would be set on November 10th at 8 a.m. But if we would like to set it on an interpreter docket day, then we can do November 5th at 1:30 p.m.
Would an interpreter typically be available on the November 10 docket if we set it for that date?
We can have one available and have one scheduled, Your Honor.
Okay. Well, let's do that then. I think Mr. Regier's point is well taken, that if that's sort of normative for cases involving Mr. Patterson, let's try to adhere to that methodology. So I will set this for November 10 at arrive at 8 o'clock for a 9 o'clock hearing.
Okay. Voy a aplazar su caso para la fecha 10 de noviembre. Va a tener que estar presente a las 8 de la mañana y la audiencia va a empezar a las 9.
¿En qué parte es la corte? Porque no tengo claro la dirección, nada.
And what is the court's address? I don't have it. I don't have it with me.
Would he be able to come in by Zoom that day as well, Miss Destiny?
He would, Your Honor. Let me make sure that we have his email on file.
Por favor, averígüeme si el abogado va a estar disponible por Zoom en esa fecha. Si su señoría, déjeme verificar.
We do have his email on file, so we could send him the Zoom codes through email, or his attorney, Mr. Patterson, could as well.
Si tenemos su correo electrónico registrado, y entonces vamos a enviar los códigos de Zoom a su correo electrónico, a su abogado.
All right. And I think I'm just looking at the charging document to see if the courthouse physical address is there, if he should need it.
201 West Pine, Judge.
All right. Sir, the physical address is 201 West Pine in El Dorado, Kansas.
Señor, la dirección física de la corte es el 201 West, la letra W, Pine, en la ciudad El Dorado, Kansas.
¿Pues qué?
Pine, se escribe Pine, P-I-N-E.
Ok.
And Mr. Regier, do you have any typical requests in terms of getting photograph and fingerprints in circumstances such as these?
Enrique, ¿usted tiene alguna solicitud que se haga típicamente en estas circunstancias en cuanto a tomarse las fotografías y las huellas dactilares?
Your Honor, the ticket in this matter does appear to refer to a notice to appear date of today's date and time, and count 2 does appear to be from the state's understanding a Class B misdemeanor. Therefore, the issues of booking and bond as required under KSA 21-2501 do appear outstanding. The state is not opposed to an owner cognizance bond in this matter, but the state is recommending at least a $1,000 OR bond in light of the charges currently before the court, although I'm not sure count 1 really matters for that purpose. Traditionally, the state understands that the court does order individuals into breakout rooms with court security for the purposes of scheduling booking.
Okay. Mr. Cunu Perlaza, do you have anything you'd like to say about any bond or booking matters?
Y señor Cuerno Perlaza, ¿usted tiene algo que usted desee, que usted quiera agregar en cuanto a la fianza o las fechas de sus fechas de disponibilidad?
Sobre la fianza, ¿a qué se refiere?
And what do you mean by bond?
The prosecutor is asking that there be an own recognizance bond to appear on that November 10 court date.
El fiscal está pidiendo que se le ponga una fianza para presentarse a esa fecha a la corte del 10 de noviembre.
They are requesting a $1,000 bond, which, if there was a failure to appear, could be owed to the state by Mr. Perlaza.
Y entonces lo que se indica es que se le va a poner una fianza de $1,000. Si usted falta a la corte a esa fecha que se le indicó, entonces a usted le tocaría pagar esa fianza, señor Perlaza.
Ok, entiendo.
Okay, I understand.
All right, I will authorize the issuance of a $1,000 OR bond and that arrangements be made with court security for booking.
Ok, entonces voy a autorizar que se le imponga esa fianza de $1,000 y entonces usted va a coordinar con el oficial para que entonces le programe la fecha para tomarse la foto y las huellas.
Pero entonces,
Right.
una pregunta, ¿la corte siempre tengo que ir hasta allá o va a ser igual online?
One question, do I need to go to the courthouse or can we do it online?
At some point, you will need to go to the courthouse or perhaps even the jail to get the fingerprints and photographs.
En el momento dado, usted tendrá que ir a la corte o seguramente tendrá que ir a la cárcel, pero es para tomarse las fotos y para que le tomen las huellas digitales.
Esa parte, ese punto no lo he podido entender de las huellas digitales y las fotos. No he podido entender ese punto.
I did not understand that part about having the picture and the fingerprints taken.
Okay. I'm sorry, you say you do understand that?
Your Honor, that he does not understand.
Okay. Sir, for certain classes of misdemeanor offense, it is required that a defendant be booked.
Ok, señor, lo que sucede es que ciertos delitos menores requieren que usted se le tomen, usted se le tomen esas cosas, la foto y las huellas.
Ok, y otra pregunta, en caso tal de que el abogado que se ha asignado para el día de la corte no puede asistir, ¿qué sucede?
Okay, I get it. And if the attorney is not able to show up to the court hearing, I mean, what will happen next?
Well, I suspect very strongly that the attorney will be present.
Okay. Yo tengo bastante certeza de que el abogado va a estar presente.
If the attorney did not appear and Mr. Perlaza was present, we would simply give him a new date.
Pero si se da el caso de que usted está presente, pero su abogado no va, entonces nosotros ponemos su corte para otra fecha.
Ok, y la foto y la huella, eso es ahí mismo el día de la corte.
And will I get the picture and the fingerprints taken on the same day as the court?
That is possible. And when we've finished, I'll allow you, Carlos, and Mr. Perlaza to coordinate with court security about those specifics.
Es posible, pero cuando terminemos, señor Perlaza, yo lo voy a poner a hablar con el oficial para que él le dé la fecha y el lugar donde le van a tomar las fotos y las huellas digitales.
Ok.
Okay.
All right. If there's nothing further on this case, before I ask Ms. Destiny to send Mr. Carlos and Mr. Perlaza to court security too, I did want to make inquiry. Is there a Cesar Granillo Holguin present on this meeting?
Antes de llevar al señor Perlaza y al intérprete a una sala pequeña de grupos, quiero saber si el señor César Granillo está presente.
Aquí estoy.
Sí, aquí estoy.
I'm here.
All right. Mr. Carlos, if you could do me a favor, I'll have you go to the court security too with Mr. Perlaza to make those arrangements. Then if you could please come back and we'll take up Mr. Granillo Holguin's case at that time.
No problem, Your Honor. Will do.
Thank you.
Okay, guys, I think that's the end of that hearing, and that should be the end of our day. This was always good to spend time with you guys, but frankly, a little bit exhausting. I need to go stretch my legs and resort my brain because I have an incredibly busy day to pile on top of all of this. But you know, you never know what you're gonna get on a live show, and today it was a lot of heavy things. But I appreciate spending the time with you guys anyways. And Barbara, thank you for sliding in that gifted membership there at the end. Very much appreciated. And welcome to Jen Carroll, who now has a membership. So we will be back tomorrow, which is Thursday. And Thursday was the new Wednesday. I think that's how that goes. 10 a.m. Eastern, 7 a.m. Pacific. A half an hour early again for channel members. Look forward to seeing you all then. In the meantime, brush off the heaviness of this and go try to have yourselves a great day, and look forward to seeing you tomorrow. Take care. God bless.